Please. No, it's okay. Start. You first file and give the number. Then. Okay. Get it in the first of itself. Inform the other side. Whether GMC is MDA, both Mr. Bora. Burua. Get it at 2 o'clock. Mr. Sharma. Monday. Monday.
And two other matter for admission.
23rd.
23rd. Debut.
Hello, yes. Concern of the petitioner's counsel, Malad, I beg you, item number 38, Malad, hearing matter. Some difficulty on my part and his part also, some hearing matter, 38. After 3 weeks, Malad, today I have some difficulty, Malad.
Give us a date.
September.
Both of you are here, give us a date. It's an any hearing date, give us a date.
September 7. Huh? 12 of September, Malad. 12 or 14. 12. I'm obliged, Malad.
My please, Lordship, I beg to mention item number 33. Director has filed an affidavit in opposition. Lordship, we want to file reply. Kindly 4 weeks may be granted, Lordship.
Let the matter reach. We'll allow you.
Lordship.
I beg to mention for withdrawal, my withdrawal for withdrawal.
Monday or Wednesday?
Monday.
Lordship, I beg to mention item number 23 of the daily cause list.
Yes.
Matter may be listed after 2 weeks.
Have you informed the other side?
Lordship, we have to file the affidavit in reply, so we are seeking some time.
What's your good name?
G. Das.
You're praying on whose behalf?
MK Sharma.
I beg to mention item number 20, Lordship. The engaged counsel, Mr. AMS Mohammed, is suffering illness, Lordship. So he asked me to take time, Lordship.
Have you informed the other side or not?
Lordship, I will inform, Lordship.
You will inform first, you inform, then I make a mention.
Lordship, he is suffering illness, Lordship.
Okay, fine. You first inform the other side.
Lordship, I beg to mention the matter for listing for orders. Matter pertains to contempt case and last dated was 7th August 2023. The Honorable Court ordered that matter will be listed after 1 week. So today is 11th since the date of last occasion. So matter is very also urgent as because petitioners will be over
23rd. Wednesday.
I beg to mention item number 4, my lord. Department have filed an affidavit on 11th of August, my lord.
Let the matter reach. Very old matter.
My pleasure, Lordship. I pray for listing of a writ petition, my lord, for admission, my lord. Matter pertains to non-payment of the contractual bills of the petitioner, my lord.
25th.
And my similar prayer, another writ petition, that the petitioner is the
25th.
I'm obliged.
I like to mention two matters. One is writ petition and another one is review petition for listing in next week.
For what? We will come for orders. And the writ petition for what?
So also for orders.
Okay. For orders, you come on 23rd.
23rd. Lordship, with due consent of the other side, I beg to mention item number 22, Lordship. The department have filed the affidavit. We need 1 week's time to file our reply, Lordship. Obliged, Lordship.
May I please, your Lordship? Lordship, I beg to mention for listing of the writ petition pertaining to a railway transfer, Lordship. Today at 2, Lordship.
When did you file?
What, Lordship?
When did you file?
Today, yesterday, Lordship.
You have the filing number.
Yes, Lordship.
Railway transfer.
Railway transfer, Lordship. We have already filed earlier a writ petition. Your Lordship has pleased.
Railway transfer. He is an employee of the railway.
Yes, Lordship. RPF members. Obliged, Lordship.
Inform Lordship. Item number 20, Lordship.
You have informed.
Mr. Gogoi, Lordship. Kindly 2 weeks, Lordship.
May I please, yes, Your Lordship? That's why I would like to mention for item number 39, the hearing. Lordship, praying for an adjournment today. Kindly accommodate this day. My senior, his father's monthly tithi today is.
Seven. Okay, it will be on 7th of September.
7th September. Obliged.
May I please, Lordship, I beg to mention a matter for listing. It contains service of teacher of provincialized school.
For council, you want to list it for orders or for what?
Motion.
When did you file?
It's been 10 or it came once, but last month, filed last month,
Okay, on 23rd.
23rd of which.
May I please?
Service book.
You pay your cost. You have to pay cost. Hold on. You see,
Lordship.
read it. Read it.
Director Secondary Education subject regarding pension proposal in respect of Srimati so-and-so, retired principal, case number so-and-so. In inviting a reference to the subject cited above, I have the honor to submit herewith a present status in regard of Srimati so-and-so, retired principal so-and-so. That Madam, the pension proposal of the concerned retired principal has already been initiated by the Office of the Undersigned as per proposal for pension paper submitted by the school authority. But Madam Sri Nita Borua, retired principal so-and-so, has not yet submitted her required documents along with the service book, which is to be verified by the Office of the Inspector of Schools. The service book is in her own custody. She received for her service book on so-and-so from so-and-so Office of the Inspector of School, Tinsukia, District Circle, Tinsukia. That Madam, due to non-submission required documents, the pension proposal could not be processed. As such, the person concerned as well as the school would be submitted to the pension authority. Lordship, in
You have to pay
second-
cost.
Lordship, I have to take instruction.
Nothing is, that is what happened. They will tell lie or what?
Lordship,
You have
that-
given
that
on the date when
instruction-
you have received the service book. Very
Lordship-
much is there. Miss Gora, nothing. Ask the
Lordship,
petitioner to
kindly
pay
may
cost.
take instruction, my lord.
Nothing, no
After
instruction.
sometimes, after sometimes. After sometimes.
Even if you then you have to pay cost, even after some time.
Lordship,
You have filed
because
this petition on the proper instruction of the petitioner. It's not your fault.
That
If the petitioner hasn't informed you that she's keeping the service book and filing a petition for her pension, how will you entertain?
Lordship, that instruction,
Yes, you have not been informed by the petitioner. It's the fault of the petitioner, not fault of the council.
Lordship, after sometimes, I,
But petitioner have to pay cost. Keeping the service book with her and praying before the court for pensionary benefit.
Lordship,
How do you expect the officers of the education department will work?
obviously, Lordship.
Then
Take up
You have-
after sometimes.
okay,
Lordship.
but no respite.
Obliged.
Matter number 46.
They were to furnish instructions whether the
Find out Mr. Esdas. Find out Mr. Esdas and then kindly inform Mr. Esdas, standing counsel, Haraduti. Supposed to give the information at 10:30. Otherwise, at 2 o'clock, the director has to personally appear. Nine.
Well, in this matter, well, your lordship was had appeared, my lord, in the case.
Is it?
Yes, my lord. 8/5/2000, can you see it? Order dated 8/5/2013.
Please before any other thing.
My lord. Obliged.
Two and three.
Please, Lordship. On the last occasion, respondent were asked to file the affidavit, Lordship.
Lordship, we have received instructions, Lordship. The petitioner in item number 2. Libby. Computer elaboration. In item number 2, Lordship, the petitioner attained the age of superannuation on 31st October 2018, Lordship. As per HSLC pass certificate. Therefore, issue of appointment letters of tutor to Srimati Aruna Kons does not arise, Lordship. In petition, item number 2. same in respect of item number 3 also, Lordship. In item number 3, we have filed our affidavit, Lordship. All of here, please. All of here, absolutely.
Anything? Item? Yes. Okay. We haven't received. Oh, okay. Earlier one. Yes, what is your case?
Lordship is not receiving salary since August 2007, Lordship. From
For receiving salary, what is the law? For receiving salary, what is the law?
here is one single man's order is dear Lordship in this petition, Lordship. Case number 60, Lordship.
Please tell us the background, how she was appointed, on what basis?
Appointment letter is appointed on 30 September 1989, Lordship.
What is there? The appointment letter. Can we read the appointment letter? Can we read what is there? Let us see in the appointment letter.
Lordship. Lordship, it is on page number 21.
Please read.
Srimati Aruna Koch, a local candidate having been passed the HSLC examination, is hereby appointed as assistant teacher in the Jiadhal Patirsuk Lower Primary School in the pay scale of rupees so and so per month against a vacant post of Sri Ratneshwar Gogoi, teacher, Jorkota Primary School, who retired. This appointment is purely temporary and she may be terminated from service without any prior notice. She is hereby directed to join her duties within a period of 1 month from the date of the order and report the undersigned through the Circle Assistant Inspector of Schools.
That is Block Elementary Education Officer, not Circle. Why have annexed the order of the court passed earlier on 25th of April 1988 in Civil Rule number 212 of 1987? Why you have annexed Annexure 1? Why you have annexed Annexure 1 at page 16? Any idea why you have annexed? Tell us, tell us.
Lordship, here is a point, pair number 3. Qualification, matriculation, or
Why you have annexed this particular order of the court? There must be some reason, right? Otherwise, you would not have annexed. Why you have annexed it?
pair number 3. Yes.
Please read paragraph 2 of your read petition at page 4.
That the petitioner submits that she appointed as assistant teacher in Jiadhal Patirsuk LP School in Dhemaji district against the leave vacancy vide an order dated 3989 passed by the office of the Deputy Inspector of Schools, and in the process she has gathered sufficient experience. But the government order number so and so dated so and so, which provided amongst others the percentage fixed for filing up the vacancies, stood in the way of their regular appointment, as they did not possess the qualification of basic training course. Accordingly, a group of experienced teachers, including the petitioner, approached this honorable court by way of filing writ petition being civil rule number so and so for redress of their grievances. The said writ petition was disposed of on 25/4/1988 by this honorable court, holding that untrained teachers were not totally debarred from getting appointment, and the honorable court further directed that the cases of the petitioners therein, including the present petitioner, shall be considered in the light of this observation.
Now, as per this particular paragraph, the petitioner herein was appointed against the leave vacancy. can there be an appointed against the leave vacancy in a government school or in a provincial?
No, Lordship.
What was the procedure at that point of time when the petitioner was appointed for any such appointment in provincialized school? What was the procedure?
Yes, very well.
Are you aware what was the rule at that point of time? Because schools were provincialized in 1977. Rules came in force in 1977. So what was the procedure at that point of time?
But petitioner was regularized, Lordship.
Have you ever read Umadevi? If any illegality is there, by regularizing that illegality can be cured.
No, Lordship.
Now, herein the petitioner was appointed by one deputy inspector of schools, Dhemaji, without any selection. Petitioner herself stated that she was appointed against the leave vacancy on 39/1989. Now, only thing is, this writ petition was of 1988. And as because in the advertisement there was a specific clause that preference shall be given to the trained teachers. So they came to the conclusion that since they doesn't have the training, they will not be considered. So they approached. At that point of time, the writ petitions were taken by the division bench, and the division bench clarified that yes, it doesn't mean that untrained teachers will not be appointed, but the trained teachers will get the benefit. They will give the preference if they are selected. Now show us at the time of your appointment on 39/1989, where was your selection?
No, Lordship, there is no selection.
There was no selection.
Selection
If
is-
there is no selection in violation of Article 14 and 16, if somebody is appointed, even if it is regularized. Now please come to the order of the court at Annexure 4, where you are the petitioner. That's serial number 5, page number 25. This writ petition was of 1988. This is a contempt petition because non-compliance of the earlier order of 25/4/1988. There, the court have specified again. Whatever is the order passed earlier on 25/4/1988, it needs to be followed. Following that, was there any specific direction for appointment of the petitioners? But you were appointed. Although there was no direction. Now the apex court, 3 judges bench settled the law. You will be entitled to salary only when you are appointed to a public post validly. Where is your valid appointment? Tell us. To get the salary.
There is a regularized order.
That's why I'm asking you. When you're not appointed, following the provisions of Article 14 and 16, will you be able to claim salary? It's up to the government. They may stop your salary because you have not been appointed. Then, so was the law that you should be paid even if you are appointed illegally and regularized. So was the law for your claim.
Lordship, at present, it is not available with me.
You have, do you think that there is some kind of law, somebody is appointed illegally and the government regularize or some scrupulous officers regularize your service and you'll be entitled for salary? You have to go through a particular process.
Yes, Lord.
And that process was where you have again filed your application in terms of the advertisement issued by the court, in terms of the order passed by the court and advertisement issued by the government, where the government found that you are an irregular teacher or illegal teacher and decided to consider you as a tutor. By the time when it was considered to be as a tutor, you are already retired.
Retired, Lordship.
Then where is your claim? You know, you should have a valid right to claim for your salary, right? And valid right for your claim for salary will come on the basis of your valid appointment.
Lordship, petitioner retired on the 2018.
That is why your prayer here is for payment of salary. Tell us how will you be entitled for your salary? Where is that law for the salary?
But from 1989 to till 2007,
She was receiving
have
to a particular, fine,
received-
it's good. It's a good luck for her. At certain point of time, government verified, found you to be without any valid appointment order. They have stopped. And they have a right to stop if you have been appointed without any right. So was the law. That's why we were asking you. So was any law by which the Honorable Apex could have laid down illegally appointed, serving regularly, should be paid salary. So was any law. You will have number of judgments from our High Court. But so was any law laid down by the Apex Court in that regard. You have the right for your salary to a particular post when you're appointed in that post following due procedure of law. When your appointment is valid. So was your appointment was valid.
My Lordship may come to page number 60, Lordship. There is a judgment, Lordship.
60 years.
66 Lordship.
Page 66.
60.
60, yes.
Here is one point, Lordship. In the para 9, second para, the question whether they are illegally appointment or otherwise do not arise for consideration. It was further held that on the principle of quantum merit, the salaries are required to be paid, Lordship.
Print করাটা আছে, তুমি উলিয়ে দিলে। এখন প্রিন্ট করতে এখন প্রিন্ট করতে না বেরিয়ে যাচ্ছে। না লাগে সাইটেশন তারপর সাইটলি Yes, Mr. Talukdar,
My lord.
are you appearing?
Yes, my lord.
But you cannot appear. Please come to page 16. Page 1616. Once you appear against the government, against the petitioner,
Yes, my lord. That was earlier.
so how will you appear for the same petitioner now? Once you have appeared against her?
Oh, it would understand. Civil 212/87.
Ask her to ask her.
Today is fixed for filing affidavit, my lord.
Hold on. Everything will come. Top we have underlined. Which court has passed this order? The top. How many judges? How many judges you have underlined?
Two lordship.
Two. Find out how many. How many?
Three lordship.
Three judges. Date of the judgment.
7/1/2004 lordship.
7/1/2004. Turn to page number 7. You have underlined. Kindly read those underlined portions slowly.
The right to salary or pension after retirement flow from a valid and legal appointment. The consequential right of pension and monetary benefits can be given only if the appointment was valid and legal.
Right? Now come to the judgment you have shown before us. Page number 59.
Yes, Lordship, 59.
Date of the judgment,
26/5/2015.
bench constitution, single judge, division bench,
This is a single bench judge.
single bench. Kindly come to the particular para which you mentioned,
It is in page number 60, Lordship.
60. Before that, you read the last paragraph of page number 59. Page number 59, last paragraph, the issue with regard to.
The issue with regard to entitlement of salary in respect of teachers similarly situated and hailing from the district of Dhemaji has been decided by the division bench of this court in a batch of lead appeals. The lead case being so and so by judgment and order dated
What is the judgment date?
18/3/2015.
Okay. Then,
The said rate appeals were decided in favor of the teachers and against the appellant state. The operative part of the said judgment and order dated 18/3/2015 passed in the rate appeals reached as under.
so there, where there is a particular observation, when the respondents are continuously serving as teacher, the question whether they are illegally appointed or otherwise, if matter less, right?
Yes, sir.
And if for the service rendered by the provident available by the state, quantum of merits, and salaries to be paid. Now tell us, which judgment do we have to follow? The judgment passed by the apex court, the three judges judgment passed by the court, by the apex court, or this particular judgment by division bench?
Definitely, Lordship, that one.
Why? Why we should follow the apex court three judges judgment? Our high court has passed division bench judgment. We have to follow this. We have to pay them salary. Which?
Yes, our one, Lordship, Honorable High Court.
Our court?
Yes.
Or which will prevail? The Supreme Court judgment, three judges judgment will prevail, or this division bench judgment will prevail? Difficulty is nobody was placing before the court. What is the law laid down by the apex court in 2004, and this is a judgment of 2012,
Yes, 2012.
right? Nobody placed before the court. Now tell us whether in a humanitarian condition, the court can pass any mandamus. But the law of mandamus will be there for a humanitarian condition.
Yes, Lord.
Yes. Are you sure? That power is only with the under Article 32 before the Honorable Apex Court. Full benefit, not by the high. Not under Article 20. That is the difference to 26 and 32. It is the Honorable Apex Court who has the power under Article 30 to do that, not under Article 226. Though we prepare any writ petition or prayers, full and complete relief, that power is there. Because that is the last court. Tell us, now which will you follow? Definitely, the three judges judgment passed by the Honorable Apex Court in the year 2004, that will prevail over this judgment. Now what will happen? Yes, ma'am.
The Lordship, High Court order has been passed after this.
Definitely, but it was not considered. That's why I'm asking you.
Yes, this suggestion will be considered, Lordship. 2012 one.
At this point, we are not on that. The difficult, that's why I'm telling you that quantum of merit will come only when there is a valid and legal appointment. Mr. Sharma, throughout Assam, what is the number of post of teachers in provincial high school? Throughout Assam, total number of post of teachers in provincial high lower primary school. Don't know. Why?
No, sir.
Why you don't know? Why? What is the salary required for payment of teachers every month? You don't know. Mr. Finance, Mr. Gogoi, tell us what is the requirement every month? We don't know. Every month, how much amount we pay as a salary to the LP school teachers? How many crores?
FTM.
Where do you get that money? So you, whom to want, you can pay. Whom to love, humanitarian condition, you are paying everyone. Will you pay? See, no answers. So ultimately, what will happen? You have a right to claim salary or no? Okay, we'll pass the order. Mr. Sharma, Monday you will tell us the total number of posts of lower primary school teachers in Assam and what is the salary to be paid to them. Last month, how much you have paid? Month of July. What's your good name?
A. Das, Lordship.
Full name?
Angana Das.
And Mr. P. Sharma. Hello. Please take your seat. Such and such land council for the petition. And Mr. Inch, Standing Council Department of School Elementary, what is response number 1, 3, 4, 1 and 3 to 6. As well as Mr. B. Gogoi, Standing Council Finance. What is response number 2? It is contended by the petitioner that the Deputy Inspector of Schools, Dhemaji, on 30/09/1989, appointed her against a leave vacancy in Ziad Hall, Patrichuk Lower Primary School, Hemaji. The state government in the education department issued an order wherein certain reservations against the vacancies of assistant teachers in in the primary schools were specified by an order dated 26/09/1986, wherein 50% of the total posts was to be appointed on the basis of merit. 10% was reserved for the candidates of Shohid families, victims of foreign national movement family. 10% for the candidates of sons and daughters of retired school teachers. 10% for the candidates of expired lady widows. 10% for the candidates working in venture adult educational or other temporary posts, and 10% for candidates working as teachers for 5 years on honorary posts who are pre-primary / normal trained. The petitioners, along with 31 others, preferred the writ petition being civil rule number 212/1987. Challenging the said order dated 26/09/1986 of the state government in the education department, that as the posts are only for the trained pre-primary, for the pre-primary normal trained teachers, though they are serving, will not be able to participate in the selection process. The court, after hearing the parties by order dated 25/04/1988, disposed of said civil rule number 212/1987 with the observation that the percentage wise division mentioned in the letter dated 26/09/1986 of the government has to be read along with rule 3 within bracket small Roman 3 within bracket small a of the Assam Elementary Education within bracket provincialization bracket closed rules 1977. And the court made it clear that while selecting candidates according to the percentage-wise division, preference should be given to candidates trained in senior basic, normal and junior basic training courses as required by rule 3 within bracket small Roman 3 within bracket small a. in all the aforesaid categories of reservation, Rule 3 of the 1977 Rule 3, in all the aforesaid categories of reservation. The court, by the said judgment and order at the 25/04/1988, passed in civil law number 212/1987. Categorically observed that untrained teachers were not altogether debarred from getting appointment, and specified that preference shall be given to trained teachers and not that untrained teachers will not be appointed at all. However, the state respondents, according to the petitioners of said civil law number such and such and others, did not comply with the said direction of the court dated 25/04/1988, and as such preferred a contempt case, being contempt original petition within bracket, civil original petition within bracket contempt bracket close 105/1988, including the petitioner hearing. The court, by order dated 29/08/1989, in the said such and such contempt, clarified that no action shall be taken by the respondents within bracket the elementary education department, which would be in violation of the order passed by the court earlier within bracket 25/04/1988. Observing that if the respondents would violate the said order at the 25/04/1988 in any way, they would be dealt with appropriately in the contempt process. Thereafter, the respondents in the education elementary department took steps to terminate all those teachers after due scrutiny whose appointments were not found to be valid, pursuant to the orders of the court dated 25/4/1988, passed in civil law number such and such, and 29/08/1989, passed in said contempt case number such and such. The petitioner stated that the along with five others preferred a writ petition WPC number 5222/2008, stating that their services were adjusted subsequently against regular vacancies and are aggrieved as the respondents stopped their salary with effect from August 2007. And they apprehended that their salaries were stopped on the ground that they were appointed beyond the existing vacancies. The court, by order dated 23/02/2011, disposed of said WPC number 5228/2008 within brackets Srimati Pioli Kosari and 4 others, including the petitioner and State of Assam and others. With the directive that one, as claimed by the petitioners, they would produce before the Director of Elementary Education Assam certified copies of the orders of the court, if any, pursuant to which they claim to have been appointed to the post, USA, which they assert here holding since the year 1989, along with other documents, if any, attesting their participation in any selection contemplated by the rules preceding their appointment. Two, the aforementioned state authority would scrutinize all relevant records, including those produced by the petitioners, as above, and examine the tenability of their claim for salary from the month of August 2007, as claimed, verifying inter alia as to whether they are rendering their services against the posts claimed by them. 3. If on such verification, the appointments of the petitioners are found to be valid in law, and if they are found to be actual in service against the post claimed by them, the Director of Elementary Education Assam would pass consequential and appropriate orders in connection with their salary. Thereafter, petitioners approached the Director of Elementary Education Assam with the said order of the court dated 23/02/2011, passed in WPC number 5222/2008, preferred by the petitioner along with 4 others. And the Director of Elementary Education Assam, after verifying by the order dated 27/03/2014, found the appointment of the petitioner as not valid in law, as they were appointed against non-existing posts, and rejected the claim of salary of the petitioner. Against the same, the petitioner approached in contempt case 66/2014, which was dismissed on 23/04/2014. Against certain orders of the court, the state preferred writ appeal 301/2012 and other connected cases, wherein the court observed, by order dated 23/04/2014, observed that the petitioners and all such teachers serving in Dhemaji are continuously working as teacher, and their salaries being paid by virtue of the orders of the court, and arrears of salary from July 2007 were not paid to them. The Honorable Division Bench by the said order dated 23/04/2014 observed that when the respondents within bracket teachers, petitioners or teachers of the Dhemavi petitioner / corridor are continuously serving as teachers, comma, they question whether they are illegally appointed or otherwise, it matter less. However, for the services rendered by the private respondents and availed by the state on the principle of quantum merit, the salaries have to be paid. In that view of the matter, court did not find any ground to interfere in the order of the single judge, and accordingly dismissed those appeals preferred by the state again with regard to the order dated 23/11/2022 passed 23/02/2011 passed in say WPC number 5/222/2008. Some other teachers preferred a writ petition, being WPC number 1764/2008, within brackets, Srimati Dayavati Dutta and two others, versus State of Assam and others, wherein the court, by order dated 26/05/2015, while disposing of say WPC number 1764/2008, observed that the division bench in writ appeal number 301/2012 by judgment in order dated 18/03/2015 has already observed that when the respondents are continuously serving as teacher, the question whether they are illegally appointed or otherwise it matters less. And for the services rendered by the respondents and availed by the state on the principle of quantum merit, the salaries have to be paid. And as such, the court directed for payment of salaries to those petitioners in WPC number 1764/2008 for the period from August 2007 within a specified time. The petitioner approached this court along with four others in WPC number 3470/2015 against the said order dated 27/03/2013 passed by the Director of Elementary Education Assam, rejecting the claim of the petitioner and others of WPC number 522 for their salary. The court, by order dated 17/12/2015, dispose of say WPC number 3470/2017, 2015, directing the Director of Elementary Education Assam to redo the exercise in terms of the order dated 23/02/2011 passed in 5/222/2008. Setting aside the said order dated 27/03/2011 passed by the said director earlier. To consider the case of the petitioner and pass appropriate orders within the specified time. For non-compliance of the said order by the Director of Elementary Education Assam, the petitioner have also passed in such and such level 3470/2015 dated 17/12/2015. The petitioner for the contempt petition in contempt case C370/2016. By preferring this writ petition, the petitioner, amongst others, prayed for a direction to the respondents in the Elementary Education Department to pay the monthly salary, to pay her monthly salary from August 2007. To regulate the recruitment and conditions of service of teachers of elementary schools provincialized under the Assam Elementary Education Provincialization Act 1977. The state government in the education department, elementary education framed the Assam Elementary Education Provincialization Rules 1977 under provides to Article 309 of the Constitution of India. The said 1977 rules came into force with effect from 1903-1979, which was first amended in the year 1997. At the time of appointment of the petitioner, in the year on 30/09/1989, the process for appointment in terms of say 1977 statutory recruitment rules was that under Rule 3.1, there shall be a valid advertisement in newspapers from desirous candidates registered with Employment Exchange, prescribing minimum qualification of matriculation, public high school living certificate examination, or any other examination of equivalent standard being the minimum qualification for the post of teachers in lower primary school and junior basic schools. Where preference to be given to the candidates trained in senior basic, normal, and junior basic training courses. Full stop. As per the said Rule 3.1, the number of posts category-wise and reservation for scheduled caste / scheduled tribe or other backward classes, etc. for vacancies of elementary school teachers existing in the year in the subdivision was to be notified. Such select list was to be authenticated by the district elementary education officer of the district, either by this to be authenticated. The said select list to be authenticated either by the director or the district elementary education officer of the district as directed by the director. As well as the deputy inspector, director of elementary district elementary education for middle schools and the deputy inspector of schools of the subdivision. The petitioner, the petition categorically stated that the Deputy Inspector of Schools, Dhemaji, on 30/09/1989 appointed her against a leave vacancy and posted her in Ziad Hall, Patrichuk Lower Primary School in district Dhemaji.
Annexure 19, Sub-Inspector of Schools Dhemaji has prepared the bill on the basis of the attendance he is present in the school.
Annexure 19.
19, page number 70.
Yes,
Yes.
we'll come to that. The petitioner it is not the case of the petitioner that after due advertisement and selection, she participated in the selection process and thereafter, on being selected, she was appointed and posted by the Deputy Inspector of Schools, Dhemaji, on 30/09/1989. The petitioner has also not stated her registered number with the concerned employment actions as required under Rule 3.1 of the said 1977 rule. The court by the order dated 23/02/2011, passed in WPC number 5222/2008, very specifically observed that was preferred by the petitioner along with 4 others, that if the appointments of the petitioners are found to be valid in law and if they are found to be actually in service against the post claimed by them, the Director of Elementary Education Assam would pass consequential and appropriate orders in connection with their salary. The said decision of the learned single judge passed on 23/02/2011 in WPC number 5222/2008 was upheld by the division bench of this court on 18/3/2015 in writ appeal number 11. Because said finding learned single judge passed in such and such on such and such. Has become valid and absolute as neither the petitioner nor the state respondents preferred any appeal against the said finding of the order beyond the court dated 23/02/2011. Petitioner placed before the court a certificate issued by the headmistress of Ziad Hall Patrishuk Lower Primary School dated 15/05/2017 that the petitioner since the date of her joining in the said school was receiving her salary regularly, but received up to 1/7/2007. Pursuant to the suo motu order passed by the division bench of this court, the Director of Elementary Education Assam, by issuing necessary advertisement on 01/02/2012 and 04/02/2012 in local newspaper, invited applications from the illegally appointed teachers throughout the state in response to the said advertisements. Applications were received from such category of teachers after conduct of preliminary examination at the directorate level. The Elementary Education Department constituted 5 screening committees headed by the divisional commissioners concerned and principal secretaries of the 6 scheduled areas and the BTC to examine those applications. Then a committee was formed by the government in the elementary education to verify those materials. The committee prepared 3 lists, LSTS, based on the screening committee report. List 1. Teachers who have received salaries up to 2007 and onwards and having junior basic training, public diploma in elementary education were included in the list number 1. List number 2. The teachers who received salaries up to 2007 and onwards doesn't have junior basic training, public diploma in elementary education, and those who are included in the list number 2. List number 3. The teachers who neither received salaries nor having the prescribed training of junior basic training / diploma in elementary education. Later, after a series of discussions, it was decided to resolve the issue of illegal/irregular appointment by way of preparation of a cabinet memorandum for placing the same before the cabinet. In the said cabinet memorandum, it was specified A or B. A. Approval was sought for accommodating those teachers who have received salary up to 2007 and have successfully completed the junior basic training / diploma in elementary education course by creating personnel/supernumerary post with prospective effect from the date of approval of the cabinet, specifying that those posts will cease to exist as and when the incumbent retires from service. That contains the list number 1 teachers. B. Approval was sought for those who received salary up to 2007 but have not acquired the professional qualification before 2011. Observing that their job can only be accommodated as tutor with prospective effect from the date of approval of the cabinet. The state cabinet gave its approval on 07/10/2020. The state cabinet gave its approval on the said cabinet memorandum prepared by the authorities in the elementary education department of the state. The name of the petitioner was considered in the list B as she received salaries up to 1/7/2007, but doesn't have the requisite research training of junior basic training, diploma in elementary degree. And accordingly, the authorities, though incorporated her name on the list too, but after the cabinet approval dated 07/10/2020, no offer of appointment letter could be provided to her as a tutor, as in the meanwhile she attained the age of superannuation on attaining age of 60 years as per her class 10 pass HSLC examination certificate. It is class 10 HSLC examination pass certificate on 31/10/2018. Considering above, the government, the respondents in the elementary education department could not consider the case of the petitioner to engage her as a tutor after the said cabinet memorandum dated 07/10/2020. Though petitioner asked before the court for her monthly salary from 2007, August 2007. Relying on the division bench judgment dated 18/03/2015, passed in the appeal number 301/2012, State of Assam and another versus Arunima City and other connected writ appeal, as well as the order dated 26/05/2015, passed in WPC number 1764/2008 in Srimati Dayavati Datta and two others versus State of Assam and others, as well as the order dated 17/12/2015, passed in WPC number 3470/2015, Mr. Soruna Post and four others versus State of Assam and others. But as noted above, the court on 23/02/2011 in WPC number 5222/2008, Piali Kochari and five others, including the petitioner versus State of Assam and others. The direction of the court dated 20%. for such salary of the petitioners therein, including the petitioner. The court categorically observed that the appointments of the petitioner should be valid and the petitioner herein failed to place anything before the court to show her appointment dated 30 09/1989 as an assistant teacher of such and such school was valid following the provisions of Article 14 and 16 of the Constitution. Though the Honorable Division Bench in its order dated 18/03/2015 passed in WPC number, read appeal number 301/2012, State of Assam and others versus another connected appeal. Observe that the writ petitioner / teachers as continuously working as teachers and salaries are being paid by virtue of the court order, arrear salary from July 2007 being not paid when the state authorities are where they are serving continuously as teacher. The question whether they are illegally appointed or otherwise, it matter less. And as the services rendered by the writ petitioners / private respondent as the case, whereas availed by the state on the principle of quantum merit, the salaries have to be paid, being followed in various other orders by the court, placed before the court by the petitioner by the order dated 26/05/2015 passed in WPC number 1764/2008, as well as order dated 17/12/2015 passed in WPC number 3470/2015. Corona Court and other parties. It is to be noted herein that much before those orders dated 18/03/2015, 26/05/2015, and 17/12/2015, the Honorable Supreme Court, consisting a bench of 3 honorable judges, in the case of R. Vishwanatha Pillai versus State of Kerala, categorically observed that the right to salary or pension after retirement flow from a valid and legal appointment. The consequential right of pension and monetary benefits can be given only if the appointment was valid and legal. In the case in hand, with regard to the appointment during the year 1989, the Assam Services District Provincialized Service to 1977, a statutory recruitment rule under Article 309 of the Constitution of India was in force. The petitioner failed to place anything before the court that her appointment was valid and legal following the said 1977 statutory recruitment rules. Though the petitioner served as alleged by her and said Ziadhol Parteshuk Lower Primary School district of Dhamaji since 1989 and not received her salary from August 2007. The court, in terms of the said decision of the Honorable Apex Court, was by three judges bench in the case of R. Vishwanath Pillai, noted above, is not in a position to pass any such order in favor of the petitioner for payment of her any such arrears salaries from the year August 2007 during her early service in the state school till the date of her retirement on following the decision of the Honorable Division Bench of this court. It is seen that learned counsels for the parties appearing in those writ appeals as well as the subsequent writ petitions did not place the said and judgments of the Honorable Apex Court passed in the case of R. Vishwanath Pillai in the case of Ram. For the reasons as the petitioner failed to place anything before the court pertaining to her appointment following the due process of the Article 14 and 16 of the Constitution of India and the Assam the petitioner your report is not entitled for any such salary and her appointment not valid. The instructions placed before the court by Mr. Sharma standing counsel 11 be kept as a part of that. Who is appearing in the next case?
Lordship. In item number 3.
Please come to page number 11. Your order of appointment. please come to the order of your appointment.
Yes, Your Lordship.
Please come to order of your appointment at page number 11. Kindly read.
Subject to discharge without notice and without assigning any reason thereof, Srimati Sasimai Gogoi Sipsagar is hereby appointed as Assistant Mistress in Ramugao LP School under BEEO Kelwa in the scale of pay rupees 1185 to rupees 2395 and other government admissible allowances with immediate effect for a period of 90 days against the vacant post Vice Sri Pradeep Bauri, Assistant Teacher of 82 numbers COG Pam LP School, placed under suspension.
So as the rules by which any such teacher can be appointed against a suspension vacancy. So as the rules. We have heard there was a statutory rules. They were appointed on 18/11/1995. Right? So that statutory rules was very much in force. So it was amended only in 1997 for the first time. So as the rule that the basis of said rule is appointed against a suspension vacancy. And there are such rules that can be appointed against suspension.
Your Lordship, I wouldn't be able to.
Right? We have heard the order we have passed in the previous case. So first of all, you have to establish your right that your appointment was valid and legal to have the salary.
Lordship, we have been receiving our salary till 2012.
Good. Thereafter, you have not.
No, no, no. And gratuity has been received. Gratuity has been received.
You have received gratuity.
Yes, Your Honor.
Good. Whatever you have received, very good. Now the salary part, let us see. Mr. Sharma, what is your instruction?
Lordship, here we have filed our affidavit. Yes. Lordship, the similar matter, Lordship. Here also the petitioner has attained the age of superannuation as on 31/1/2018. And he appeared before in the meantime, he appeared before the screening committee, Lordship. He has attained the age of superannuation. As a result, he could not be either accommodated as teacher or teacher. Our affidavit is there, Lordship.
What's your good name?
G. Rangma.
G. Rang. Mr. G. Rangma, Ariyan, counsel for the petition. And the PN Sharma and the counsel department for school education for the respondent numbers 1 and 3, 2, 6. Who is for AG? No representation on behalf of the respondent. The Director of Elementary Education Assam have filed a detailed affidavit.
Lordship, this affidavit has been filed by the secretary, Lordship.
Sorry, Secretary, not Director.
Lordship.
Secretary Government of Assam and the Department of School Education. In the case in hand, the Deputy Inspector of Schools, Natira, an order dated 15/11/1995, appointed the petitioner as an assistant mistress in Ramugaon Lower Primary School under Khelua Education Block in the scale pay of rupees 1185 to rupees 2395 and other government admissible allowances with immediate effect for a period of 90 days against a vacant post by Sri Pradeep Bauri, assistant teacher of 822 number Seuji, SEAUGI, Pump, Lower Primary School, placed under suspension. The said appointment of the petitioner was extended from time to time by the Deputy Inspector of Schools, Nazira, and secondly, by another order, dated 30/01/1996, the petitioner was appointed as assistant mistress in Ramugaon Academy for a period of 90 days by Sri Nilonath Kotoki, retired from Lokimi Jan Lower Primary. By another order, the same Deputy Inspector of Schools, Nadira, by order dated 22/04/1996, in continuation of earlier appointment order of the petitioner dated 30/01/1996, appointed her as assistant mistress at Ramugaon Lower Primary School, same place against vacant post of Sri Nulonath Kotuke, retired from Lokimijan Lower Primary School. Later, the said Deputy Inspector of Schools, Nadira, order dated 27/09/1999, confirmed the service of the petitioner as an assistant teacher of Ramugaon Lower Primary School from the date of joining, from her date of joining on 30/01/1996. Petitioner later certificate for primary education from IGNOU. Has filed this petition on 06/03/2019. Prem amongst others for direction to the respondent authorities in the elementary education to release our salaries. It was withheld from March 2012 to January 2018. I feel the date of his data, our retirement concerns. Though the petitioner was found to be illegally appointed teacher by dean and deputy administrator of schools, Nazira, without any selection process against non-existent post. He holds the Rule 3 of the Assam Elementary Education within the Provincial Act 1977. Our case was rejected for payment of any such salary from first March 2012. As a service found to be illegal in nature and honest in the eye of law. The petitioner failed to place anything before the court. That after due process of advertisement and selection, and after her due selection in terms of the state 1977 statutory recruitment rules, she was legally and validly appointed by dean and deputy inspector of schools, Nazira, in state Amugaon Lower Primary District of Chhatrapati. Under Kelu Education Block of District. Considering this petition being given that stands.
Lordship, I have gone through that, but your Lordship, there are certain issues, your Lordship, which I just want to point out, in which needs some explanations from my part, your Lordship. First of all,
basically, you come before the court, no problem. You are in, you have retired from service.
Lordship.
You have a right for pension.
Lordship.
Pension has been delayed.
Lordship.
The thing is this: if you continue to possess the service book, your service book, how the authorities will process with the?
That's what I just want to point out, your Lordship. Your Lordship, my retirement date, your Lordship will kindly note 31/5/2022, and according to them, your Lordship, this service book was handed over to me on 24/3/2023. For your Lordship, 1 year, what they did, your Lordship?
That is not the issue.
No, your Lordship.
No,
I will explain you. I have an instruction from my client, your Lordship, immediately on receipt. I went there, your Lordship, to hand it over to them. Even yesterday, your Lordship. But your Lordship, they did not accept that, your Lordship. Number of occasions, 18th time. And your Lordship, if necessary, I will file it by an affidavit, your Lordship. And no, your lordship will kindly, my provisional
all-
pension, why they have not, your lordship, really sealed that, your lordship?
See, the Chief Secretary of the state before the court,
Lordship.
swearing an affidavit categorically stated that following the pension rules of
Lordship.
6 months prior to
Lordship.
their retirement, the authorities will prepare the pension paper and the pension.
Lordship.
Now, tell us here, 6 months prior to her retirement, when did she approach the authority for proposal of?
Not
corporate loan?
6 months, your lordship, but immediately after retirement, your lordship.
See, it cannot be both
Three
ways.
representations. your lordship.
After retirement, we have seen many such teachers approaching the court at the last moment,
Lordship.
showing that as
Lordship.
per their such and such, their service should be extended. Many teachers
Lordship.
continue to service for a long period.
Lordship.
We have found even 3 years, 4 years,
Lordship.
right?
Lordship.
And getting salaries, and
Lordship.
keeping silent.
Lordship.
They are claiming their.
Lordship. I
pension
agree.
papers. There
What
are
has
various
for-
kind of categories of teachers you have
Lordship.
seen. Now, what we want to know is, if the petitioner is having, maybe for some reason, the respondent authorities have not prepared, and the petitioner earlier approached. But say, we can see all fault on the others. Have you ever mentioned that when did you file this writ petition? You have filed this writ petition on 26th of July 2023.
Lordship.
And tell us when it was given to you.
There is no reason, your lordship, the person concerned told me.
See, we want to know from you.
Lordship.
Yes, Mr. Sahari, when it was given to her,
Lordship. On 24/3/2023.
24/20.
2024.
That means on the date when this writ petition was
Yes,
filed by the
Lordship,
petitioner,
Lordship,
she was
Lordship.
having the service.
Lordship. That should have been disclosed, your lordship. That I, now your lordship, since your
Do
lordship.
one thing, we are passing an order to just place it before the authorities.
Lordship. And
You
they
have
will
the
process
instruction
it.
with us,
Lordship.
give it to us.
In fact, yesterday they have issued a letter, your lordship, not before that, your lordship. That asking me to submit the service book, your lordship. I will place it to your lordship immediately today, your lordship, and they will
Heard
process
Mr.
it.
S. Bhattakur, counsel appearing for the petitioner. And MS Sahari, standing counsel, Department of School Records, Secondary, for the respondent numbers 1, 2,
1 and 4,
1, 2,
I am
3,
again.
and MS Gidas, Roman Government Advocate Assam, for the respondent number,
1 and 4.
sorry, right. Automatic Gidas, Government Advocate Assam, for the respondent number 1 and 4, as well as MS Sahari, standing counsel, Department of School Education, School Secondary. On being appointed, the petitioner, on being appointed on 28/05/1987, the petitioner, she was a subject teacher of which subject? Mr. Bhattakur.
Lordship. That I did not put, your lordship.
Was appointed as a subject teacher at Jajodi Higher Secondary School in the district of Tinsukia. She joined her service. Thereafter, by order dated 25/06/1997, she was transferred to Manitula Higher Secondary School, district of Tinsukia. Later, by an order dated to 02/05/2017, she was appointed as principal of Panitula Higher Secondary School, district Tinsukia. and join her said post on 03/05/2017. The petitioner, on attaining the age of superannuation, 60 years, retired from service on 31/05/2022 from as principal from Said Panitula Higher Secondary School, District Tinsukia. As her stated before the court that she has neither been paid provisional pension nor the final pension and other retirement benefits like leave encashment benefit, gratuity, group insurance, etc. In spite of her approach, being aggrieved, filed this writ petition on 26/07/2023, framing amongst others for a direction to the respondent authorities to provide her all pensionary benefits as per her entitlement. During deliberation of the matter, Ms. Musahari placed the written communication dated 16/08/2023 of the Inspector of Schools, Tinsukia District Circle, Tinsukia. Respondent number 3, that the petitioner received her service book on 24/03/2023, and the same is on her custody, and that the petitioner since then have not returned her service book so as to prepare the pension proposal with regard to the pensionary benefits payable to her. It is stated that due to non-submission of required documents as well as the service book by the petitioner, her pension proposal could not be processed. It is also placed before the court by the said Inspector of Schools, Tinsukia, that on 16/08/2023, the said authority communicated to the petitioner directing her to return the service book, return her service book to the said authority. Full stop. As such, it is seen that at the time of filing of this writ petition on 26/07/2023, the petitioner was holding her service book. Full stop. After hearing the Lord Counsel for the parties, this writ petition is disposed of, directing the petitioner to submit her original service book before the Inspector of Schools, Tinsukia District Circle, Tinsukia, on or before
tomorrow, Your Lordship.
22nd of August 2023, and shall submit all the relevant documents required for submitting or preparing the necessary pension proposal or payment of pension to her, along with the required photographs and other documents before the inspector of schools in Tinsukia within the same specified date. The petitioner shall also provide her address, telephone number, mobile number, and email address, so that whatever document, photographs, or her signatures required in her pension proposal could be communicated to her by the inspector of schools in Tinsukia. After receiving the said service book and the relevant documents for the pension proposal to be submitted by the petitioner on or before 22/08/2023, the inspector of schools, along with the principal in charge / vice principal of Panitula shall prepare the pension proposal of the petitioner and shall submit the same on or before the Director of Pension, Assam, on or before 30/09/2023, subject to depositing, submitting all the relevant documents and the service book by the petitioner before the inspector of schools on or before 22/08/2020. On receipt of such pension proposal of the petitioner from the inspector of schools in Tinsukia, the Directorate of Pension, respondent number 4, shall process the same and shall disburse the final pension pay order to the petitioner within a period of another pension entitled by her within a period of 3 months, i.e. on or before 30/12/2023. If there is no other mistakes or wrong in the such said assessment proposal of the pension proposal of the petition. In the meanwhile, the petitioner shall be paid or provisional pension by the inspector of schools in Tinsukia and other pensionary benefits as per her entertainment in accordance with law, if there is no other impediment in releasing the same to her. With the above observation, this petitioner shall submit a certified copy of this order before the inspector of schools in Tinsukia as well as the director of pension.
Deeply obliged.
Obliged.
Deeply.
Of the communication of the inspector of schools in 08/2023.
Lordship, needs this matter be taken up after some time. Mr. Yukin, I am receiving this case.
Yes, I have received instruction, my lord.
Who was holding it? Definitely not the director. Your director seems to be new. Yesterday we inquired. She has joined recently. What happened? She has joined. The new director has joined or not joined? Mr. Das?
Sorry, my lord.
Whether new director has joined
No,
or yet to
no,
join?
no, my lord.
The old director is still there.
Yes, my lord.
Who was holding it?
Uh,
Who was holding this? Why you are not furnished with the instructions?
My lord,
Who was holding it? The director or somebody else?
we have communicated with.
Who was holding it?
My lord, I don't say, my lord, who was holding, my lord, but we have communicated with my lord, the earlier director.
Why did not you receive instruction? Somebody was holding it. Who was holding it?
My lord, maybe my lord,
You don't know.
office
You have
staff-
not inquired.
office staff.
Why you have not inquired?
Because they.
Court doesn't want any policing, you know. We feel bad when we pass such kind of orders.
My lord, as per instruction, my lord.
Yes, that one.
Mr. Roy. Just tell us one thing. Whether the employees of the SEBA are getting their pension?
Yes.
Now whether the employees of the SEBA are getting their pension? They are getting their pensions for the 1969, those who have joined prior to that. Now, the husband of the petitioner hearing was absorbed at SEBA and he retired from SEBA.
My lord, the petitioner, my lord, completed
7 years something.
7 years, 2 months, and 28 days.
But her earlier service
Yes, my
has to be counted.
lord, first of all, application for the post of application submitted by the petitioner, my lord, that was not so proportional also.
Doesn't matter. You have accepted his service. You are aware.
Yes.
The petition was granted lien. Mr. Nair, there is a judgment of Justice H. Roy. It's a particular case from our here only.
Supreme Court, my lord.
No. Here, Guwahati. A lecturer from Assam Engineering College was there on lien, joined Guwahati University, retired from Guwahati University, then he refused to pay his pension. Then there was a direction from the court to give that period, to count her that period in the because he rendered service in the Guwahati University. The period he rendered in the Assam Engineering College was to be considered for the purpose of pensionary benefit. This is
I'll get it, man. I'll
get that judgment. It's very clear, it's specified.
I'll get it, man. And here, my lord, one thing, my lord, I'll just like to point out. The college authorities released me in 98 because I did not rejoin. Released me, my lord. 98 because in 97, 5/1/97, I was absorbed there. So I can't have two lien, my lord. So that lien got terminated. And I came through proper channel. That is why they have given me this. And my lord,
see, in the Mr. Das, Mr. Nair, or Mr. Roy,
Lordship,
Provincialization Act was not there in the 1998 when he was released on lien from the British College, right? It was only in 2005 with effect from 1st December. So, payment of pension at that point was not the issue. By the time when he retired from service, from SEBA, the 2005 Act came into force. The government part of the CPF was to be returned and supposed to be deposited in the treasury. That was already, the time was extended by the government, the higher education department. And if it was deposited and placed before the authorities in SEBA, how will you reject the pension of the husband of the petition?
that deposit was made on 12/1/21 within that extended period.
Because it was refunded to the government. Government have accepted that. Now, once the government have accepted that, this letter of the director is meaningless. Mr. Das. Got it? So, the petitioner's husband have already deposited the said amount during his lifetime.
No, after the wife.
Within that period.
Within
There
that
are
extended
numbers
period.
of judgments passed by this court. You will see many principals have retired or might have died after retiring from service. Their wives is to deposit the CPF part of the government. They are getting pension. And that is why the 2005 Act came into force to give the pensionary benefit. Thus, it is easy to reject. But at least see this particular.
I'll get that judgment, my lord.
That judgment.
That I'll get it. I'm thankful to your lordship.
As per
I don't know whether it is reported or not, but it is.
I'll find it out. My lord. And one thing, my lord, at that point of time, neither the SEBA was pensionable nor the college was pensionable. After that, both became pensionable with retrospective effect.
But it is a fact that amount has already been deposited in the.
Yes, yes,
fund of the
21, my lord,
representative.
page 49, my lord. The original is at page 50, my lord.
I've seen that. How will you reject, Mr. Das?
And that was in terms of
Were
their.
you able to defend this order? Now that part, that the college authority have terminated his service.
Yes, madam.
Now, what was the procedure? That resolution, whether it was approved by the director?
Termination, my lord.
You have said well
Yes, sir.
that the Pragyatis College, as he did not return after the deputation, he was released, right?
Yes, madam.
But that order of the governing body of Pragyatis College, as it was not a provincialized college at that point of
Aided
time,
college.
that decision has to be again approved by the director, whether it was approved.
That information I don't
So
have, my lord.
what kind of information you
My
have?
lord, may kindly have page 44, my lord, the procedure is also some.
What, 44? What do you want to say from 44?
In the middle, my lord, in this connection, it may be stated, my lord, in this connection, it may be stated here that the GB of so-and-so college had allowed lien to so-and-so up
Thank
to
you.
21/4/98 and released with retrospective effect from 27/1/1998, and he did not resume service at Pragyatis College. So it is clear that the ex-lecturer's lien on the
Case
post
number
held by him was
8482.
terminated violating FR 14A. It is also not clear whether the transit of late Goswami from Pragyatis College to Seba had the approval of DHC government. As per Government of India instruction below, Rule FR 14A, my lord, in all cases where a government servant is to be absorbed permanently by the foreign employer under this organization, it would be incumbent on him to consult the parent employer before issuing orders absorbing the government servant permanently in his service. The order of permanent absorption should be issued only after the resignation of the government servant has been accepted by the government and with effect from the date of such acceptance. But late
Mr.
DC Goswami,
Das,
yes, my lord.
your authorities can always reject.
Yes, my lord. But there
Right.
was, my lord, as per instruction, my lord, there is no resignation from his part, my lord.
Your authorities can reject, but did not see that the amount was already deposited. So you are getting an interest on that amount. That remand money was already returned.
Dr. Upendranath Mishra. And my lord, that letter is actually in my favor. He is, my lord, questioning how can you have terminated his lien, my lord. That, my lord, will be clarified from the principal's letter, which is Annexure 1, my lord. Page 18. Therein, my lord, the facts have been stated. Upendranath Mishra. My lord, I've got it, my lord. It's 2009 1 GLR 78.
Justice Roy's judgment.
Lordship. '78. টার্মিনেশন হতো নিজের রিলিজ করে 12 পেজ 119 কারণ ই ঘূৰি নাহিলে ইয়াতে কনফাৰ্ম হৈ গ'ল আৰু লাষ্টতো the original service book so and so were furnished to Seva's request and so no record of deposit of so and so. ইয়াৰ ওপৰত কেনেকে যাব কোন আছে ডাইৰেক্টৰ এতিয়া কোনে দিছে
Okay, we'll come back at 2.
Lordship.
Just Mr. Nair,
Lordship.
during the break, find out there is a the earlier management rules.
Edit management rules, my lord, yes, I got it,
All the if you have to release someone from the post because it's a grants in aid college.
Lordship. It will
Funds
have to
paid by
take
the
permission of the director.
It has to be the approval, the resolution have to be approved by the director.
Director. I'll get that. Edit rules. Education management.
See, basically, there are certain important issues involved in this petition. We found that the principal secretary of the department, His Highness, we have directed the chief secretary of the state to file an affidavit in that regard. The chief secretary was totally silent. We have seen the chief secretary constituted the selection committee. The principal secretary of the department's name was not there, but he procured an order from the chief secretary of the state to be a member of that committee as just an observer. But it was found in the record, it is the same principal secretary being an observer of the committee, prepared the resolution of the selection committee, fixed on a date, let us assume the 30th of August, but he prepared the minutes months ahead, giving the preference to the private respondent, which was signed by the chief secretary. These things, anomalies are there in the records. But both the persons have retired and we did not wanted to proceed for the academic purpose. But basically we have observed this kind of, we would have in fact, it is there in the order, but we would have loved to do something in the records. Correct. Against the state, because when you asked the chief secretary was totally silent in the affidavit. He was specifically asked, how come he can look into all this? Being an observer, he prepared the minutes, recommending the private respondent much before the actual date of holding the selection board meeting. This indicates the highness of a particular officer heading the department, being the principal secretary. Right? And worst part was the chief secretary. He was totally silent when being inquired by the court. In his affidavit, he is hopelessly kept silent. He allowed, as because they are from the same category, that administrative officer category, brother category, he remained silent. Mr. Nath
should not have been.
Should not have happened.
Not correct.
Probably that kind of chief secretary is not expected to perform as a chief secretary. The flaws were placed before him. He was aware. But anyway, Buddha persons have retired, so we do not want to proceed further for the purpose of academic. But these are the indications. Now we have seen how the Honorable Apex Court are holding these matters every time. Belaying the Honorable Chief Justice of India is very much looking into all these aspects. Now see. So we have just, as because influx was because Buddha persons have retired. Otherwise, we would have asked to proceed against him.
Definitely.
We have closed it. That's all. Written is
All three matters are,
Yes, there's a government record
yes, my lord.
that you can see at page number 125. Now itself, you'll know.
I'll
Record to Hana.
check it. Yes, it's-
Record to Ahipale detail.
it's a better application. My lord.
And APSC record is who is representing APSC? You are take back the record.
How long, my lord?
Just see the page number 125. We
Yes.
have marked it.
Yes, sir. I'll check.
Good results.
Alok Kumar. Alok Kumar. Content to liberty local effect to claim damage. This cannot be secluded. সেইটো সময়তো এইবিলাক হেৰি কৰিছিল।
Lordship may grant us liberty to claim damages because due to the
You know very well the reason. Go to page number 125. Orders, it's not the notices. Notice is something different. Go to the 125. Read that off. Probably we have marked it. Read it loud.
Agenda note for the selection board meeting to be held on 26/11/2019.
So to be held on. So it's a prior and see his signature. And ultimately same thing copied from this and this to be held on. It was in favor of the private response.
26/11.
These are the records.
Correct.
Okay, that's only for your purpose to see.
Lordship.
If this petitioner and the respondent would have continued in service, would have asked him, and particularly the chief secretary, why he was silent when the court passed an order. He did not answer in the affidavit. It's available in the record.
Lordship.
The Burua, Sanctorello. Okay.
My lord. Okay.
Mr. Nair, we'll take this item little after. Some motions are there.
I'm here, my lord.
Okay, we'll call it
But
after some time.
My friend, my lord, was expressing some difficulty, my lord.
actually I thought it, my lord.
See, basically, that man has retired from SEBA.
Yes, sir.
And wife of the petitioner, sorry.
husband.
The husband already deposited the contributory fund provision of the government side.
Government.
Already deposited that within the time specified. So either from SEBA or from the higher education department, whether is entitled for pension or not.
Oh, yes, yes.
That is the issue.
Now, last occasion, what happened, my lord, we are agreed to pay the pro rata pension, my lord. That's why my learned senior friend told me that we okay, Sabha will give it. Then I thought it, my lord, I have not gone through the brief today.
No problem. Pass the order some other day. But
Some
thing is
other
this,
day,
what are the particular things of this? The higher education department has rejected it on the ground that earlier the Praxotis College while asked him to return because the deputation period was not extended. So necessarily he did not join. Already he was absorbed in the SEBA,
SEBA.
the controller of examination. So he did not join. As he did not join in Praxotis College,
He was
he
released.
was released, he was
Released.
terminated, right? He was released or terminated?
Release, man.
He was released.
And that's in 2012, the principal's letter.
But anyway, so again, any such order Because there is not provision for termination and
18, my
release.
lord, section 80, rule 18 of the aided rules,
76.
76.
Management rules provides that it has to be signed by the director.
Director.
Approval has to be given. You are aware. So in those days, it was a grants in aid college. Any such decision of the governing body has to get the approval is to have the director signature. And if it was not there,
If
it
it's
is there, if
termination,
it is not there.
It's not there.
That
gone.
means,
It's
you know
not there.
very well.
Fix a date, my lord, and I would have go.
My lord, I'll have it on Monday or Tuesday.
That part,
my lord.
Lordship, I will clarify. That part I will clarify. Lordship will fix it. Otherwise, today also I can clarify that part.
What will be your stand?
Lordship, our stand will be, as and when he is permanently absorbed in that particular post, Lordship, his lien shifted to that post in the Seva, Lordship. Now he is entitled for pro rata pension as per the rules, and we send it to the Seva, Lordship, that amount, Lordship. And the judgment which was referred by my lord, it's not applicable here. It is really defined footing because paragraph 10 very specific. Paragraph 10 is that, Lordship, in the Guwahati University, that person was not permanently absorbed, Lordship. So, Lordship, his lien was in the parent department. That's why Honorable Court decide the case in favor of the petitioner. Here the picture is totally defined.
Here he was a permanently.
Here permanently absorbed. The apex court time and again retired. I have the judgment. I will place everything, Lordship.
So if permanently absent, it will go.
Then
to the
it will
Seva.
be amount to a resignation. Technical it deemed to be a resignation. Otherwise also, Lordship.
My lord, technical resignation is for the purpose of lien, my lord.
Technical resignation, even if permanently absorbed, Lordship, it automatically goes to that particular lien to the post where he has exhausted.
Consider.
So his right is not in our department. His right
And
goes to the Seva, Lordship.
My lord, that money which is due from the higher education, if they pay that to the, my lord, Seva, that will also serve my purpose.
Pro
my
rata
lord.
pension, that will, what the amount pro rata pension which will petitioner will get, that will transferred by the government to the Seva, Lordship, and Seva will decide other issues. Similarly situated persons approach the Honorable Meghalaya High Court. Honorable My Lord Justice, thank you, has decided the matter in favor of the petitioner by observing that the pro rata pension amount should be transferred by the Higher Education Department to the Nehu University, Nehu, Lordship, and after that Nehu will decide as per the provisions of law.
My
I will
lord,
place the
it's-
judgment also.
My lord, the pro rata pension came to me from Seva only because 7 years of service. If this 30 years of service gets added, enough, my lord.
That part Seva will decide. That part we cannot say that. We
But
only
he'll
say
have to
that
pay the money,
we
my lord.
only say that the amount which will be in our department. That part will send. That was only
And the
decided
money
cases.
which I got from Seva, my lord, I had deposited with the authorities. my lord.
He is not an employee of our department when he is permanently absorbed. He is lien shifted to Seva, Lordship. And that issue was well settled by the Honorable Apex Court. When he is permanently absorbed in the other department, then everything goes to that department, not vested to our department. He is not an employee of our department. I will address everything. Lordship may fix a date.
My lord, Seva in the communications have repeatedly asked that the money is not being given to us, so we cannot do it.
Mr. Nair,
Lordship,
next time we'll be arguing the matter. Still, you'll just find out what was the salary that was fixed when you become permanent.
my lord, when I came to the Seva, they protected my that salary and they fixed my salary.
Then
It's there on record.
Then Lordship, his past service is already Lordship protected. If
That's
the
what I'm saying,
if
my lord.
salary is
They-
protected,
If it is past services protected, that
then
means
he will
be
get
entitled to
entitled.
pension.
My lord, I
pension.
came on
We will only send that.
That's my case, my lord.
We will only send
Now
that.
what had happened here, my lord, my lord, my friend did not get excited. My lord, what had happened here was,
I am
my
not
lord,
excited. I am
He
not
is
excited.
defending his department.
I am
let
not
him, my
excited.
lord. I'm not
You are
against him, my lord.
defending your client. I am
No,
defending
I'm
my
not against him, my lord. What had happened was, when this dispute was going on, the government asked me, the director asked me to deposit the money. This money is not the CPF dues which I got from the higher education department. This is the CPF dues which I got from the board. I deposited 50% there, madam. It was the understanding that the board now they will not give, the department will give. But the correct approach would be, my lord, this money has to go to the board and the board has to release this amount.
Because it was permanently absorbed.
Absorb them. And that period will not vanish because it was technical resignation and that period comes here because I came on lien, my lord, and they accepted me. Today they say it was not through proper channel and all. Those will not work because in the advertisement it is there. Person in service have to apply through proper channel.
Do you have that the skill that you receive at the time of your
Lordship. My lord will have my letter at page 23, my lord. (23), my lord, 1, 2, 3, 4, fourth paragraph, I said I applied through lien. Fifth paragraph, my lord. When I left the college, I was a selection grade lecturer drawing 4,420. It would be, my lord, it should be, my lord, 4,825. And
no, in the original letter it is 48251.
Lordship. Then when I came here, my lord, they protected that, my lord. I'll just place that. My lord would come to page 52, my lord, their affidavit. The last 4 lines. On receiving the last pay certificate from his earlier college, the board fixed his pay and the same was protected as per service rule of the board.
The time will consider.
Lordship, my lord will have it next week, Tuesday. My lord, it's fresh with the. If not otherwise, my lord.
Can you have it on 7?
Lordship.
7.
Lordship.
Immediately after holiday.
September.
Thursday, my lord. Fine, my lord.
For further.
My lord will keep it part of
Just have further here.
Lordship, that will do.
Lordship.
Sorry.
Ms. Pachaji will appear for 3. And Director of Pension will appear.
Government advocate appears.
Anyone is appearing for response number 5, Pragyutis College?
Pragyutis College. Cause list to cause list kon thane.
तो नाम लिखो।
दोनों से जाएंगे। No one is.
Nobody is appearing.
This is complete on the response number 5. ID card received back
Lordship.
after service. But none appeared.
None appears.
Because in the name of principal of Pragyutis College. Served on 12th of April. Mr. Gugoi,
Lordship,
should the director inform the principal of Pragati?
Lordship. Apologies.
Section number. Four. The scene that service is complete on the response number 5. But the said response has been done for the parents of that.
Apologies.
Sorry for interrupting your lordship, my lord. In the morning, I made a mention for unlisted motion, my lord. The registry has now stopped it. It's a bench 4 matter, my lord. Well, saying that, my lord,
It has to go to the appropriate bench.
my lord, only thing that, my lord, that is not difficulty, my lord. But they are saying that mention before this court was not tenable, my lord.
I think so that was what is the procedure. It has to be mentioned before.
The senior most bench I have mentioned, my lord.
Should I have approached the court number, the bench 4?
M. Chaudhary cannot take up the matter, my lord. Because he,
M. Chaudhary cannot take up the matter. Inform the RG.
my lord,
Inform the register general wherever it is placed. Okay.
I'll place it before Register General. Sorry.
Production list item number 1.
Please, Your Lordship. My lord, the petitioner are members of Railway Protection Force. My lord. Earlier, they filed a writ petition challenging the force order whereby they have been transferred to different division in violation of the directive number 58. My lord, Your Lordship disposed the matter and found that the writ petition has become infructuous on the basis of a communication submitted by them, my lord, and further clarified that the force order shall now be deemed to be from 31st of March 2024. Thereafter, my lord, we have submitted the copy of the order. Your Lordship, kindly say annexure is 75 million. Thereafter also, my lord, they have started sparing the petition. And being angry, we filed another writ petition, my lord, but the same was withdrawn with liberty to refile in appropriate forum. And we have found, my lord, that the CAT has no jurisdiction to entertain this petition, and hence this petition, my lord. You should kindly say page 75. Your Lordship closed the matter on 2/8/23.
Yes, madam. Will not they come under earlier notification that it starts from that?
Lordship, my verbal instruction is that Lordship, they have sought for some clarification that although in the letter it is stated that the tenure will be from 31st of March 2024, but whether till then, what steps should be taken, whether spare orders can be issued or not, there are some communication according to the authorities, and they had sought for some clarification. In that process, Lordship, they had issued the spare order, and they are waiting for a clear clarification, Lordship, from the railway board.
Right. So only when that clarification will be given by them, because otherwise that period has to be counted from.
Yes, they understand is that it will be counted from 31st March but till then whether they could be spared
Some
or not.
observation
Yes,
will have to be given.
yes, Lordship.
Now, the fresh cause of action will arise only when there will be clarification is given by the
Yes,
authority
Lordship. Yes,
with
Lord.
regard to their date of that 31st of March 2024. So don't disturb even this period unless you get the clarification.
Let it be come up on Monday, Lordship. I have also intimated them that in fact there is an order, and now this is a bit difficult also from my part also to state that, because on the basis of that letter that was closed, Lordship, and they asked me to talk for some time, at least till Monday, Lordship. They have sought for clarification.
We'll do
That
one. We'll have it on Wednesday.
Lordship.
Wednesday. We'll have it on Wednesday.
Lordship.
Till then, status quo is on today.
Lordship.
Okay.
We have been asked to intimate our joining report, my lord. So it may be stayed, my lord.
Will not stay. We'll make it status quo. You got your test as on. Not Mr. Raido.
My lord, then, my lord, we have already been spared. What will some protection may be given?
London. CGC. You are appearing for all?
All, Lordship.
What is respondent number? One. Though the petitioners hearing transferred petitioners hearing relay constable is against the force order. Where is the first force order?
Yeah.
Where is that force order?
Force order, my lord.
And 24 and 25, Lordship. 24 and 27.
Number 24 of 2023. Dated 21/7/2023. As well as force order number 26 of 2023. Also dated 21/07/2023. Transferring them to various places and that the Railway Board, the Ministry of Railways by its order dated 31/07/2023 observed that such date of tenure shall be deemed to be from 31/03/2024 . for the purpose of tenure transfer. The authorities in the NF Railway by communications dated 08/08/2023 directed the petitioners to report their respective place of posting by 19/08/2023, being no, not by 20/08, applicant 20/08/2023, being spared from their respective place of posting on 08/08/2023. It is stated that though the Railway Board in its communication dated 31/07/2023 categorically observed that the tenure will be from 31st of March 2024, their order of sparing them from the present place of posting on 08/2023 by the Railway Protection Force NF Railway, being bad in law, should be set aside and passed. At this stage, MSP and FCGC has prayed for some time to obtain necessary instruction in the matter. As the board, Railway Board, by its letter dated 31/07/2023, specified that the 31/03/2024 is the date to start the tenure of the RPF personnel in terms of force order number. What will be the present place of posting of those transferred RPF personnel during this period? It is also submitted by MSP that the respondent RPF NF Railway is waiting for such clarification from the Railway Board in the Ministry of Railways, Government of India. Based on (23rd or 25th? Tell us. Give us a date so that you can get the instruction.
Then 25th.
25/08/2023. Till then, the order of transfer of the petitioners under force order number 24/2025 pertaining to petition shall remain.
Lordship, one thing, Lordship, they had annexed spare order of only 5 petitioners. So whether issued to all or not.
We do not know. That's why I have suspended your.
And Lordship had stated that 19 and 20 in cases also, Lordship, 29 is also the date to join there, Lordship. So different dates. 19/8/23, 20/8/23, and 29/8/23.
19/8/2023 to 22/8 or 20.
20 and 29 is there.
19/20.
Lordship, it is status quo, Lordship.
We have passed the order not to give reports of that nature.
Please, Lordship, last time your Lordship had the interim bail was granted.
Case there is here, Lordship. Their last date of entry is Lordship 12/8/2023. They are not able to collect the birth certificate, Lordship.
Lordship, the more.
Oh,
More.
sorry, Jani.
Minor hobo.
Victim.
Dispute for an item.
Birth certificate.
That's possible.
Lordship, the man is now 78, my lord. Lordship, only CPA 35. This condition. What the informant father is doing, my lord? This man is issueless, my lord. But he has a lot of property. And he is forcing this old man to sign and give some property to them. He refused. And ultimately, my lord, just immediately after the bail was interim bail was granted, he files another application that I am harassing him. The man buried already on saline after FIR, yes.
So the up to dates are all previous. The bail was.
And Lakshmi may kindly see page 35, my lord, the condition of the man of my application. FIR is the annex. Sorry, is the annex.
Please take it. Heard. Mr. R.P. Chairman, our senior counsel. Assisted by Mr. A.M. Bormia, counsel for the petition. Part. Honorary Relation of Post Address. For the state. By this application under section 438 chapter C, the petitioner, namely such and such, is seeking rearrest pay connection with Hailakandi PS case number 48 of 2005 under sections 354 in bracket capital B of 506 IPC, rated section 8 of the POCS Act 2012, corresponding to the year number 201 of the 2020, and special in bracket box case number 111. With regard to an incident occurred on 13 2023, victim's father on 16/02/2023 lodged an FIR before the officer in charge of Hailakandi police station. That was registered on 27/02/2023. In the said affair, the father of the victim alleged that his daughter, the victim, on 13/02/2023, when went to the house of the petitioner, who was unwell, or to help him out in cooking his foods and others. The accused petitioner grabbed the victim from the backside, tried her, grabbed the backside, touched her private parts, and forcefully tried to commit rape. The said FIR, the informant also stated that date of birth of the victim, his daughter, the victim, 13/01/2007, and at the time of occurrence of the incident, she was 16 years old. Earlier petitioner preferred accordingly such and such case. Earlier, petitioner approached this court for his bail in say such and such case number such and such, being AB number 1102/2023. And the fourth, initially by order dated
24/3
24/3 2023 granted interim bail to him, pursuant to which the petitioner appeared before the investigating officer of the case of such and such on zero 2023. However, on perusal of the case, the court, by order dated 27/06/2023, rejected the interim bail of the petition in said such and such case. This is petitioner's second bail application, pre-arrest bail application in said case number such and such. Peruse the case there, recorded up to 12/8/2023. It is seen that the investigating officer of the case is yet to seize the birth certificate of the victim. However, on perusal of the case, it is seen that statement of the victim was recorded on zero 2023. And while deposing before the learned judicial magistrate, first class Hailakandi, on 03/03, the victim stated her age to be of 16 years. Further, the concerned JMFC Hailakandi on 03/03/2023 inquired from the victim about her age and the victim submitted before the court that on 03/03/2023 she was about 16 years old. And as such, learned magistrate came to the finding that the victim is a minor. The 164 CRPS statement of the victim recorded on 03/03/2023 by the learned JMFC Hailakandi available in the case that discloses sufficient incriminating materials against the petition regard to his involvement in the alleged crime. It is also seen that the concerned investigating officer of the case in his note categorically recorded that after allowing the interim bail to the petitioner, the petitioner along with few other persons threatened the informant of dire consequences for lodging the affair against him relating to the present case. And in that regard, the informant, on the information given by the informant, one non-affair case under section 107 CRPC, by Hailakandi PS Police Station, non-affair case number 56 of 2023 has been registered against the petition. It is also seen from the case that the concerned investigating officer of the case was to approach the court for rejecting the interim bail of the petitioner granted to him on certain indices. Considering such materials in the case, there is an involuntary petitioner in such and such case. The court is of the view that it's not a fit case to grant pre-arrest bail to the petitioner in such and such case. Though petitioner have next
35, my lord.
prescription dated 24/07/2023 regarding the sufferings, medical sufferings, regarding the medicines prescribed by doctor to him, but that relates to type 2 diabetics and hypertension. The court is of the opinion is not
And
sufficient.
page 35 may be seen, my lord.
That the and is also receiving saline but if you are a diabetic, you are taking saline, what will be the outcome?
My lord, outcome is that he, due to old age, my lord, he is
If you
about
are a diabetic and take a saline, what will be the outcome?
I don't know, my lord. But he is due to old
Ask
age.
the doctor, he'll let you know. The person, the
No, not
concerned
that
doctor
one.
who has given the prescription.
Because it is due to his weakness and old age, he was given saline. That may be.
Considering the court is not trying to press and pre-arrest bail petition stands. rejected.
Only, my lord, one thing your lordship may also, my lord. Considering age, if the police arrest him, my lord,
Let him go to police and surrender. Thereafter, we will consider.
Lord, he not
Mr.
even
Sharma.
supposed to walk, my lord. Anyway, my lord.
You see the rise of these cases in Assam, particularly. from the
Yeah, my
time
lord,
of
it was
COVID
actually
now.
a land dispute. In the FIR itself, it is clear. They were, they, instead of 13-2, and FIR is for 27 say 2. And there was in between, my lord, there was a talk of compromise because his land, issueless, my lord. Town land, lot of land.
What will happen?
But he didn't want to part. He didn't want to part with it. They tried to compromise on the ground that you give some land.
If he's the owner of the land, he can give to somebody else. Not
No,
to be
he has got
complaining
he has
on
got
his
sons and
family.
daughter of his brothers, my lord. They will enjoy it. Why should they be parting with the land with the other person?
Definitely.
And allegation simply attempt, my lord, nothing.
Not at this stage. There are statements of the victim.
Victim is my lord quite grown up. She is living there in the house for last 15 years, my lord.
You have what to do.
Also, I have preferred this IF to implement the opposite party number 4 and 5 as a respondent in the parent repetition, Lordship. 4 is an Union of India, and the second 5 is the Commissioner and Secretary, Department of Labor.
Any objection, Mr. President? Yes. What, Mr. H? The council appearing for the applicant. So heard Mr. K. Kolita.
Respondent 3, Lordship. Opposite party number 3.
MS M. Bachadil and Permanent Assam for the opposite party number 1 and 2. Mr. K. Kolita and council for the opposite party number 3. Sega and HSS for the opposite party number 4. You will appear also for 5, I think.
Yes, sir. 120.
Mr. Kolita, what is the total amount you have already given for this work done? How many crores?
100 crores. I forgot because we have filed the affidavit, Lordship, stating
365 crores or something like that.
Okay.
Because that matter pending before the division.
Yes, Lordship, we have filed it.
The
Lordship,
the applicant has the petition. Refer to connected petition application number 3132/2016. Frame amongst others to increase their daily wages and to regularize and or absorb their services as members of the as security personnel members under the Director General of Police Assam and Police. The said writ petition WPC number such and such is pending for adjudication. By this interlocutory application, the writ petitioner has applicant prayed for implement of the Union of India represented by its Secretary, Ministry of Labor and Employment, Government of India, New Delhi, as well as the Commissioner and Secretary, the Department of Labor and Employment, Assam, as party respondent numbers 4 and 5 in the connected WPC number, to which the learned counsels for the opposite party have no objection. On perusal of the records of WPC number 3132 of 2016 as well as present application, the court is of the view that the Ministry of Labor and Employment, Government of India, as well as the Department of Labor and Employment, Government of Assam, are necessary parties for adjudication of said WPC number 3132. Considering the application of this present application filed by the applicant for immediate stands out. Registry shall do the need incorporating the name of the party respondent. The connected. In view of the order passed today, the connected IAC 1796 of 2023, the Union of India represented by the Secretary, Ministry of Labor and Employment, Government of India, New Delhi, 110011, as well as Commissioner and Secretary, Government of Assam, Department of Labor and Employment, Dispute the MP has party respondent
4 and 5.
in the present district. As Ms. A. Gayan Lada CCC has entered appearance on behalf of the newly employed respondent number 4, as well as Ms. no formal petitioner shall serve requisite extra copy of this to respond number 4 and 5. Newly implemented. The newly implemented notice be issued to the newly implemented. They shall file their respective affidavits in the matter on or before 22nd, 22/09/2023, placed on 27/09.
I am concerned about one issue, Lordship. Similar issue is pending before the division bench. Yes,
after that we'll let them come.
Same petitioner is.
We'll do that.
Much obliged.
Just place Mr. Kolita at the time when the returnable date when the matter is.
In this case, I have received an affidavit in opposition on Friday, last Friday, madam. I have to file rejoinder affidavit, madam. File 10 days time may be granted.
As per order dated 25/7, Lordship, we have filed our affidavit on 11th of August, Lordship. To the
Pursuant
rejoinder,
to the order dated 14/06/2023, the respondents in the agricultural department on
11/8, Lordship.
11/08/2023 have filed an additional affidavit in the matter. Mr. Counsel appearing for the petitioner prays for some time to file a reply to the said additional affidavit of the respondent of the agricultural department, respondent number 2. List after 3 weeks. In the meanwhile, the petitioners shall file their reply to the additional affidavit of the respondent number 2 filed on 11/08.
Lordship, I pray for a fixed date, Lordship. There are certain discrepancies in the documents annexed to the rejoinder affidavit.
List of the 3 weeks, anyway.
Obliged.
But I took time for filing affidavit in this matter, Malad. But what I find, Malad, there are a lot of further progress in this matter, Malad, and I have not received all the documents, Malad. In fact, AG inquiry was there. There was reply from our side. Subsequent inquiry is there, Malad, and subsequent so-called to all the persons, 4 or 5 persons were involved in that. Those developments are not with me, Malad. The instructions which I have, and subsequently also some information I received, those are not complete. I will pray for 1 week time, Malad. But along with the other reports and so-called notices issued to the others, the entire thing I have to bring it, Malad.
Heard Mr. P. Chakraborty, Council appearing for him. And Mr. T. Nath, Senior Government Advocate Assam, for the state respondents. On the prayer of Mr. Nath, the state respondents is granted further time to file their affidavit in this petition. List up to 4 weeks, and the date to be fixed.
Malad.
Interim order passed agreement.
In fact, Malad, what has happened here, the suspension order they have challenged, he has been reinstated, he is working, getting his regular salaries. There is no difficulty on that. And the second thing, Malad, the so-called charge sheet issued to him, ultimately, Malad, we find that there are developments, Malad, on that so-called, possibly the department cannot proceed now. The things have to come. Because the show-cause says that there was, because of the subsequent inquiry reports, Malad. The suspension is not a problem today. The second prayer, the charge sheet. In fact, I find from the records available that we are not in a position to proceed with this also because of the subsequent inquiry reports and the findings. But the liberty always remains with the authority. Ultimately, the action has to be taken not only against this petitioner, but there are some other persons are also there.
No, the earlier order was of
27th of June.
27th of
Yes.
June 2019.
Yes, my lord. At that point of time,
That
Lordship has,
suppose was not to give an effect.
yes,
right?
yes. So that matter stayed at that stage. No, there is no progress after that. Now the principal AG's report is there. Then there is reply from our side. Then subsequent inquiry, and my lord, ultimately fraudulent payment of 44,39,000 that has been come out. That has come out, and the involvement of not only the petitioner but some other persons are also there. So we have already issued show cause notice to the other persons, but in respect of petitioners, we are not in a position to proceed. My lord. I'll all the documents I have asked for. My lord.
File your affidavit.
Yes,
that will
yes.
cleanse
Yes,
this.
yes. Yes, my lord. We'll file.
Otherwise, it will not be
We'll file.
possible on our part to vacate this order.
Yes, my lord. Without the documents, it is difficult. It is difficult. I'll file. My lord.
The interim order passed earlier on 13 09/2023. Sorry,
Lodge.
27/06/2019.
Nothing. Lodge.
Shall remain in force till the next day.
My lord.
Yes.
Lordship, here on the last occasion, Lordship wanted to know why the 3 non-compounded advance increments were given with effect from 1/7/2011. So that instruction is awaited, Lordship. Lordship, the petitioner enjoyed her till degree prior to that.
My lord, they'll have to also take one more instruction. My lord, my lord, you see, that earlier increment that was given to us, my lord, before coming into force of this, my lord, new regulations and the government of Assam decision, those were refunded. And my lord would find the clue in the regulation itself, my lord.
Mr. That date.
No, that it's provided for in the, my lord, regulation 27/4/2012 office memorandum, my lord.
27/4.
Because what happened, my lord, the earlier what was given to us, that was refunded, my lord. And then with prospective effect, this was given. My lord. And that is permissible, my lord.
Mr. Upamendu, you have understood the case?
Yes, sir.
Just tell us, what is the issue raised by the petition? Tell us the issue involving this petition.
Lordship, what I can understand, Lordship, he was awarded, Lordship, 2 non-compounded increments, Lordship, earlier.
When?
Was there, Lordship. Lordship, with effect from Lordship 1/9/2008. Page 15.
Now, herein the petitioners have obtained their MPhil or
PhD.
So if it is MPhil, I think so 2 increment.
One.
One increment.
One.
And if it is PhD,
3 non-compounded.
3 non. There is a policy decision on the part of the government in the higher education to provide such benefits.
Yes, Lordship.
Fee increase. So here, what was that policy? What was that policy?
Lordship, page 35 is the 27/4/2012, Lordship. Annexure 7, Lordship. Serial number 10. The teacher in service awarded PhD under the earlier scheme regulation on or after 1/1/2006, and by the time of coming into force of this regulation shall be entitled to get.
There are 2 parts.
Yes.
Here all the petitioners are PhD degree holders. All are PhD degree holders, right? Now read para 9 of that.
Yes, Lordship, from the last petition.
From 8, you read 8.
My lord, then the other part, my lord, 4 also, my lord. 4 is also very important.
Para 8, Lordship, teachers who
Start
complete,
from para 4.
4.
the teacher who completed their PhD MPhil degree while in service before 1/1/2006 and received advance increment shall not be entitled to get advance increment again under this regulation, as they were already benefited as their basic pay were hiked by the advance increment on fixation on 1/1/2006.
Those who have completed their PhD or MPhil prior to 1/1/2006, they already got the benefit.
Yes,
Their salary with the increment has been already assessed as on 1/1/2006.
They will not be entitled. Notwithstanding anything in the following clause, those who have already availed the benefit of advance increments for possessing PhD, MPhil at the entry level under the earlier scheme regulation shall not be entitled to get the benefit of advance increment under this regulation.
Next.
Para 6, 5 non-compounded advance increment shall be admissible at the entry level of recruitment as assistant professor to person possessing the degree PhD awarded in a relevant discipline by the university following the process of admission, registration, coursework, and external evaluation as prescribed by the UGC who have fulfilled UGC requirement as specified in serial number 2 above. Para 7, MPhil degree holder other than those mentioned in serial number 3 above shall be entitled to 2 non-compounded advance increment at the time of recruitment to the post of assistant professor. Para 8, teachers who completed their PhD degree while in service shall be entitled to get 3 non-compounded increments if such PhD is in relevant discipline of the discipline of employment and has been awarded by the university complying with the process prescribed by the UGC for enrollment, course, work, evaluation, etc. However, teachers in service who have already been awarded PhD by the time of coming into force of this regulation or having been enrolled for PhD have already undergone coursework as well as evaluation if any, and only notification in regard to the award of PhD is awaited, shall also be entitled to the award of non-compounded increments even if the university awarding such PhD has not yet been notified by the UGC as having complied with the process prescribed by the commission. 10. The teachers in service awarded PhD under the earlier scheme regulation or on or after 1/1/2006 and by the time of coming into force of this regulation shall be entitled to get 3 non-compounded increments if such PhD is in a relevant discipline of employment of 1 advance increment in case of teacher in service who have been awarded MPhil degree. Teachers in service who have not
Yet
enrolled for PhD shall therefore derive the benefits of 3 non-compounded increments on award of PhD while in service who have been awarded MPhil degree.
Only if such.
Teachers in service who have not yet enrolled for PhD shall therefore derive the benefit of 3 non-compounded increments on award of PhD while in service only if such enrollment is with the university which complies with the entire process, including that of enrollment as prescribed by the UGC.
We need not go further, right?
Yes.
So here the petitioner,
yes,
in this particular matter,
yes,
obtained his PhD when?
On 7/9/2007.
7/9?
2007.
7/9/2007. So you will come under which category?
In service.
In terms of this office memorandum of 27th of April 2012, you will come under which category?
Lordship has obtained PhD while in service.
Tell us which category. He has obtained on 2007.
Yes.
That is September 2007.
Lordship.
So, tell us. 10 or 8?
Teacher who completed the PhD service shall be entitled. It is in relevant discipline. Teacher in service awarded.
Where is in your initial registration? Sinha. Going to be registered.
Registration.
Commander 10, you have to tell us the initial registration, right?
The Lordship.
Yes.
Let us see.
Now that particular in all probability has not been disclosed.
And definitely it's not within a year. So it will be before the 1/1/2006.
But my lord, 10, if my lord peruses 10, subject to what my lord would say, my understanding, the teachers in service awarded PhD under the earlier scheme regulations on or after 1/1/2006. And by the time of coming into force of this regulation, shall be entitled to get 3 non-compounded increments if such PhD is in the relevant discipline of employment, and 1 advance increment in case of teachers in service who have been awarded MPhil. Now, what had happened here was, my lord, it says awarded PhD. So, my lord, the relevant date would be the date of conferment of that PhD degree, which is, my lord, in my case, 7/9/2007. So, if that be so, the thing that was given to us earlier, my lord, was paid back, and then, my lord, at page 45. In pursuance to government OMB so and so is hereby allowed 3 non-compounded advance increments from 1/7/2011.
You have this file? You have this file? Yes. Page 45.
GBA.
Yes, Lord.
Give us that file. Government file, government file. The Directorate of Higher Education file. Do you have that record?
No, that's record. I only have this petition. Lordship.
So I think everything is in the same file, I suppose.
Okay, produce it on Tuesday.
Yes, Lordship.
I think it will be different files. We'll have to just check up the numbers. If this is GB bracketed, G bracketed BAC oblique ADV increment oblique 3/13/2012. 17. And the next case I find GBAC advance agreement 242/2012. Maybe it's the same file number, but the numbers are changing. One number is changing.
I'll get it for all the petitions. Lordship.
Whether on these one. So 2007.
So my email is 2007 12
years.
Registration date to आगे पीछे होगा.
माझं normally it number
on the next date
last
the Directorate of Higher Education SAM shall place the following records in original. 1 capital C within bracket B AC oblique ADV transfer A to capital advance ADV dot incrementor INCRE oblique 313 oblique 2012. Number 2.
माझो नंबर तो बोलते हैं पहले तो हमने पहला नंबर ई नंबर तो बोलते हैं याते हैं उसे 313 पे है कोई तो 216 नॉर्मली इतने के तो है बोलते हैं और वाले करने ओ পাৰে
চবতে বেলেগ
চবতে বেলেগ
মানে ফাৰ্ষ্টটো আৰু লাষ্টটো
মানে কলেজ ৱাইজ কৰে নেকি Well, my friend can write out the other details and give it. He'll give it to the
Which one?
file numbers. Man.
The file number says page 48 to be required. Other one is to recovery.
Other one is recovered.
G within bracket P AC oblique 68 oblique 2012 oblique 154. 154 no holo sir. G within bracket P UGC oblique 132 oblique 2010 oblique 93. $93 2010 হলো GPSC 68 2012 তারপর DHE oblique audit oblique 1 oblique 201 list on 22
Lordship, can it be on 24th, Lordship, instead of Tuesday?
24th.
Thursday.
Okay, on 24th.
Well, I'll give the other numbers now if required.
Let us see the first one.
Lordship.
We'll proceed with the first.
Lordship. My lord will call for two because
Otherwise
the
it
first
will
one,
be-
Vibhuti Chaudhary is a library. That is also covered by the other. My lord will also call for an assistant professor.
Oli Sharma.
Oh.
Give us the number.
Eli Sharma, he'll just. Eli Sharma is my lord.
Second item. Maybe.
My lord will have 4519/2019 Moni Sharma.
450.
That my lord would find 4519/2019.
41.
My lord, here my lord would find it at page 39. my lord.
এটা compare, এটা প্রথম item number 14.
14. my lord. 14.
No, no. আপনি মনি শর্মা কিছু না
No, Moni Sharma.
41 nahe 17 loke
14.
next to mara 14
20% full to
27 la to document ekটু আমাকে দিলে না হয়
Next, Professor Moni.
24 দিলে না হয় আনিবা GB UGC G P2 UGC 161 2011 Utin bracket P AC okay ADP and public 242 public 2001 বাকি একে দিছি
এটা নাম্বারটো বলে
What is financial schedule data finance? Okay, we'll just pass the order.
I'll inform my lord. My lord will inform.
I'll inform Mr. Solia, Lordship.
He is there.
মানে on behalf for you.
Director of Higher Education. Authorities in the Higher Education Department. AHD dot 396 public 2010 2001 of the Commissioner and Secretary Government of Assam in Bihar. AHD dot 396 2010 बाकी ठीक है
Mr. Cholia will appear.
It will be available in the this file, OM file. If it is not there, we'll see. List comes up. Copy of the order to Mr. Theo Kapil. Thank you.
Much
Highly
obliged.
Lordship. Lordship, as per the last order, the respondent number 1 and 2 are directed by this honorable court to apprise the compliance of the order dated 31/5/2018, my lord.
Yes, Mr. Khatania.
Yes, I have received some instruction, my lord, that in fact a hearing was conducted by the Commissioner Secretary, my lord, in the year 2020, and on that hearing it was found that, my lord, the concerned principal against which, my lord, the complaint was filed by the petitioner, my lord, he retired way back on 2018, my lord. Now, my lord, there is no cause of action regarding the sexual harassment and all. There was no cause of action. Secondly, my lord, the petitioner, she was absent for a long period, my lord. She was not attending her duties. Till date, my lord, she was not attending. She is not even go to the school, my lord. I think since 2012 or 11, my lord, she has not been attending her duty, my lord.
Now the status, Mr. Attorney.
Yes, my lord.
Regarding the allegations caused by the petitioner
Yes, my lord.
against the earlier principal of the school.
Yes, my lord.
The when did you exactly receive the complaint from the petitioner?
This order, my lord, that information is not there, my lord. She filed writ petition in the year 2011.
Please come to page number 16.
Yes, my lord.
Read the second part.
The matter of allegation against the principal CNS Higher Secondary School was inquired by Dipanta Ramsiari, AIS of this inspectorate. And the said inquiry report has stated that after observation of all the points of allegations and counter allegations, it may be concluded with the opinion that it is harmful and detrimental to the academic causes of the school. Hence, a proposal may be sent to the Director of Secondary Education Assam for transfer of MS Jyoti Thakuria, subject teacher of economics, to another school.
That's all.
Yes, my lord.
So this was the observation after the inquiry.
Inquiry, my lord.
But what you have done, you did not interfere with this order, this particular request.
Yes, my lord.
And the request remain only request.
Yes, my lord.
So the petitioner approached.
This honorable court, my lord.
There was again a direction from the court.
Yes.
Initially on 30th of April 2014.
Yes, my lord.
Then you started saying that the petitioner remain absent since 12th of May 2010. Now, if the inspector of school during the inquiry was of the finding that allegations raised by the petitioner to a certain extent is correct. Right?
Yes.
So that was during the inquiry. And it was the finding that the petitioner should not be allowed to continue in that particular, because the allegation was against the principal.
Yes, madam.
Whom you cannot really, may be very powerful at that point of time.
Yes, madam.
It is easier for you to remove the teacher, right? So you need to transfer her. You have not taken any action. Now, a lady teacher alleging sexual harassment in the working place.
Yes, madam.
After alleging, after making such allegation against the principal, what will be her condition of work in that particular institution? When the principal remains as the principal, the accused remains there as the head, how she will perform? You will try to find out all the flaws. So when there was a specific observation made by the inspector of school that a complainant should be removed or should be transferred to others, why you have not done? First of all. Secondly, how in such position a petitioner will work?
Yes, madam.
When the
That I
accused
understand,
himself
madam.
is the, will you be able to blame others or blame her absence from the work?
No, madam. Certainly not.
Think like that. Then you'll have the answers. See, somewhere there is an arrogance in some officers because she is a teacher, punish her, not the principal. Possible that he remain absent for a certain period. The principal, being the head, he has to administer the college, or manage the higher secondary school. He can do something, right? But thing is this, when the allegations, these kind are there, rightly, wrongly, were not there. Right? But there was an inquiry.
Yes, madam.
Inquiry has given you the clue. If it is wrong or false, you could have initiated departmental process to remain silent. The finding of the inspector of schools is very clear that they need to be transferred out because inspector is powerless against the principal. Principal appointing authority is only by the director.
Yes.
Inspector cannot do anything against the principal. Tell us.
But nothing was done, madam. During that period, nothing was done.
In that circumstances, petitioner
I'll-
is absent, we can understand, don't pay.
Yes, madam.
You are only asking for transfer now.
That is there, my lord. The situation in the year 2014 till 2018. Now, as of now, my lord, the situation is.
Since that man has retired,
Yes, my lord.
so he allowed her to live outside the school up to that period. Now your stand have changed. That as that man against whom there was an allegation, He has retired from that particular higher secondary school as principal. He should now join. You should notice to her that Mathman is not there. Now you come back and join.
Nothing was done, my lord.
Have you done that?
Nothing was done.
That
Person
is also have not done.
in 2020, my lord, the commissioner issued an order saying that, my lord, that man, an inquiry was conducted, and since the principal has retired, my lord, so no cause of action. That is the finding of the commissioner and secretary, my lord, during that time.
So what was the reason of initiating a inquiry in 2020? And the allegation was of 2010.
This is only to follow the order of this honorable court, my lord. Nothing else, my lord, because the first order passed in the year 2014. Then, my lord, 2018.
He retired in 2018. When
March
the order of the court was issued.
was issued in 2014, my lord.
Then
13th April 2014. Then subsequently, my lord, 2016. Two orders were there, my lord.
now when both the inspector of schools, both the principals of Borpeta as well as Sonitpur have accepted that she can be transferred, why this order was not passed? Transferring her to Borpeta. Now just tell us one thing.
Yes, madam.
Who is serving as a subject teacher of economics in the CNS Higher Secondary School at Sonit?
Presently, madam. I don't remember.
See, that means from 2010, the petitioner left the school in May 2010.
Yes, May 2012, May 2010.
There is no subject teacher in the school in the subject of economics. You are aware of that. Then what will happen to the students working there? What will happen?
Ultimately, students are suffering, madam.
So it is his duty to manage
This is the director, madam.
the not only the director, the department.
Yes, madam.
So, some simple things you are making it in that way. Should have transferred her when there is approval.
Yeah.
You shouldn't pay her for that period for which she had not rendered service.
In fact, there was a finding during that time. There was a finding, my lord. No work, no pay.
That's right.
But transfer has never happened, my lord.
Because there is an approval. Only because of your arrogancy, some people will not allow to go to leave. Yes, you finish it off now. What is his arrays?
one more allegation against the petitioner, my lord. Since 2009, my lord, she was running a junior college in her
For
locality.
that, you can always take disciplinary action.
Yes, my lord.
Who stopped you?
No, my lord, I'm not saying
Then
it.
allegations are there. If it is found, you'll go inquiry and do whatever. You are the power. You
Also,
have the power
inquiry,
to
my
do
lord,
that.
that allegation was there, my lord. In fact, a disciplinary proceeding was initiated against her, but she did not appear, my lord.
Yes, now you tell us. All this time, Mr. Khatanir, come to page number 35. When did you submit this format A? Have you submitted this format A?
My lord,
Please come to page number 35.
35 of the petition, my lord.
Yes.
As per the order of Honorable High Court Guwahati, passed in WBC number, so as order passed, white this and this, wherein positive consideration was made, it was agreed that Srimati Jyoti Thakuria can be transferred to Alhaji High Secondary School, District Barpeta, and subject teacher post of economics was ordered to be kept vacant. Jyoti Thakuria was required to submit of transfer format A, duly filed, in which is procedure and which needs to be submitted to government for approval as a normal procedure. But Srimati Jyoti Thakuria has not submitted the transfer format as yet. As transfer format is necessary, Jyoti Thakuria is directed to submit transfer format immediately, or else this office will not responsible for any lapse.
Now, let us assume that you are not aware of that order.
My lord.
Let us assume. Come to page number 36.
That is the contempt case, my lord.
Content. Now
My
come turn to page number 37.
My lord.
Kindly read.
Mr. Deka submits from the affidavit filed on behalf of respondent that order of this court dated this and this passed in WPC number so and so has been complied with by issuance of order dated 10/5/2016 by Director of Secondary Education Assam. In view of above, contempt petition is then closed.
Now come back to page number 35. What is that order? Which date?
That is a 10 May 2016, my lord.
So you, at least from the filing of the affidavit, you are aware,
my lord,
that there is such an order passed. That was sometimes in 2016.
My
now,
lord.
after this order, when did you submit your format A? When did you submit?
That is not with me, my lord. But I have submitted on only the written statement, my lord. That is on 28/6/16. Annexure 3, my lord. Page number 11 of the affidavit. In
What's your good name?
V. Kumar, my lord.
For the petitioner. And Mr. N.J. Khataniya, Standing Council, Department of School, Secondary. The petitioner hearing was the subject teacher of economics at Sondranath Sharma Higher Secondary School, Pithakwa, District Sunit, a provincialized secondary school of the state. she remain absent in the said CNS High School since 12/05/2010. The petitioner raised certain allegations against the principal of said CNS HS school, stating that the concerned principal of the said CNS school had sexually abused her in a working place. The inspector of school Sonitpur on 17/7/2010 wrote to the Director of Secondary Education Assam for transfer of the petitioner to another school to maintain the academic environment in the said CNS High School. The court, the petitioner approached this court in by filing a writ petition WPC 883/2011 praying for her transfer from the said CNS HS school to any other higher secondary school for the reasons indicated therein, and also to release her salary from May 2010. The court, by order dated 30/04/2014, disposed of the said writ petition WPC number such and such 8883/2011, directing the petitioner to approach the Director of Secondary Education Assam, hesitating her grievances, and further directed the authorities in the Secondary Education Department to consider the grievances of the petitioner by taking note of all the attending facts and circumstances. But the Director of Secondary Education Assam on 09/06/2014 came to the finding that as she remained absent from 12/05/2010 in her service, claim for her salary from the said date, i.e. 12/05/2010, is not tenable under the provisions of no work, no pay. And further, advised the petitioner to submit prayer petition for her transfer before the concerned authority, and directed her to join the said school till her transfer from it. The being aggrieved with said order of the Director of Secondary Education Assam dated 9/6/2014, petitioner preferred an appeal before the Commissioner Secretary Higher Education. As it was not considered, the petitioner again approached this court by filing a writ petition being WPC number 3811/2014. The court by order dated 02/03/2016 dispose of said WPC number 3811/2014 of the petitioner directing the Director of Secondary Education Assam to consider the transfer of the petitioner from said CNS HS School, Sonitpur, to Palhaji Higher Secondary School under Borpeta District, it is to be noted herein that the petitioner obtained approval from the principal of CNS Higher Secondary School as well as the inspector of school Sonitpur for her transfer to a vacant sanction post of subject teacher in economics at Palhaji Higher Secondary School in the district of Borpeta, and the principal as well as the president of the SMDC of Palhaji High School also agreed for such transfer of the petitioner to the said school from CNS HS School, District Sonitpur. The inter-district transfer is to be considered by the Director of Secondary Education. Inter-district transfer of any teacher serving in provincialized / government high school or higher secondary school is to be considered by the Director of Secondary Education Assam as well as with the approval of the government in the Secondary Education Department. It is seen that by an order dated 31/05/2018, passed in WPC number 601/2017, preferred by the petitioner, the court directed the petitioner to submit a certified copy of the said order dated 31/05/2018 before the director, before the Commissioner Secretary Higher Education, Secondary Education, who in turn was directed to pass a necessary order in terms of the order dated 02/03/2016 passed in WPC number 3811/2014. Due to non-compliance of the order dated 02/03/2016 passed in WPC number 3811/2014. The petitioner preferred a contempt case, being contempt case C 435/2016, wherein the respondents in the secondary education department filed an affidavit clarifying that the Director of Secondary Education Assam, pursuant to the order dated 02/03/2016 passed in WPC number such and such, issued an order on 10/05/2016, and in view of the same, said contempt case C/435/2016 was closed by the said order dated 02/12/2016. The petitioner has annexed a copy of the order dated 10/05/2016 passed by the Director of Secondary Education Assam, that was made available with the affidavit filed by the respondents in the Secondary Education Department in the said contempt case C number. From the said order number GB-CST/MISC/10/2010/533 dated 10/05/2016 issued by the Director of Secondary Education Assam, it is seen that the petitioner was required to submit of transfer format within column A, duly filled up transfer format A, which in turn to be before the Director of Secondary Education Assam, which in turn to be placed before the government in the Secondary Education Department for approval as per normal procedure, considering it to be inter-district transfer. By the said order dated 10/05/2016, the Director of Secondary Education Assam directed the petitioner to submit the said transfer format at the earliest. Though the petitioner has filed this writ petition on 21/10/2019 for a direction to the respondent authorities in the Secondary Education Department for her transfer from Chandranath Sharma Higher Secondary School, District Sonitpur, to Palhazi Higher Secondary School under Bapeta District, but she is totally silent as to when she submitted the requisite format A for her inter-district transfer from such and such to such. On being inquired, the counsel for the petitioner also failed to state before the court as to when the petitioner submitted such required necessary to when the petitioner submitted filled up necessary requisite format A for her inter-district transfer from such and such. From the affidavit filed by the Commissioner Secretary Government of Assam in the Secondary Education Department. Filed on 25/09/2020. That the concerned principal of CNS HS School District Sonitpur has already retired from service in the year 2018, and one Srimati Meenakshi Goswami was working as principal of the said HS School. But the petitioner even then remain absent in a service and was found running a junior college, namely Sonitpur College at Kawemari. Since long, prior to the alleged incident of sexual harassment on the petitioner by the earlier principal of the said CNS, such and such. Which have not been rebutted by the petition. Thirdly, the allegations of the statements made by the Commissioner Secretary, Secondary Education Department, as filed in the affidavit on 25/09/2020, hasn't been rebutted by the petitioner till date. Considering all above and due to non-filing of the requisite Format A for inter-district transfer of the petitioner as claimed as paid by her pursuant to the order dated 10/05/2016 issued by the Director of Syndicated Education in compliance of the order dated 22/03/2016 passed by the court earlier on 22/02/03 in WPC number 38/2004. The prayer of the petitioner for her transfer or a direction to respondents to transfer her from Sundranath Sharma Higher Secondary School such and such to Palhati cannot be considered, as the petitioner did not comply with the requisite, did not comply by submitting requisite Format A for her such inter-district transfer. from district unit. According to this writ petition being devoid of merit stands.
Obliged.
Obliged. Yes, Mr. Datta.
This is improvement, my lord, of the labor department, my lord. In fact, this is a case where, my lord, the petitioner is seeking minimum wages, my lord. Therefore, my lord, the lordship on last occasion directed, my lord, the parties to be implemented. In fact, finance department is already a party, means written in the cause list.
Okay.
But instead of water, the labor department was wrongly written, my lord, as water resources department, but it's the labor department. Water resources is already party. The last order, my lord, perhaps a typing mistake, lordship directed, my lord, that the labor department be the party. But it says, my lord, water resources department. Water resources is already party. So therefore, I've paid for implementing the labor department.
File application. I will not pass any order today. File an appropriate application by Monday.
No, I filed, my lord. I
Where is it?
have asked for implement labor.
Okay. You have filed.
Yes. I have asked for implement labor department as respond of 5 minutes.
The connected WPC number 4997/2020. The Water Resources Department and the Finance Department of the state. Finance is not a party. You want to implement finance?
No, finance is already implemented.
It's not here.
But in the cause list, the order is
That's
reflected.
true, we have seen, but there is no such order.
It's order is there, my lord. Order before that, my lord. Last order, my lord, this before that.
True. But thing is this, already there is an order from the in a full bench, you have taken a decision unless you file an application.
Well,
difficulty is even if you pass an order for implement of something, they cannot do it because in the CIS format, they have to import it.
But it's already corrected, my lord, in the cause. I found that's all in the order is corrected, my lord.
Where?
There, my lord. Last order which I've got, my lord, this is corrected, my lord.
In the petition, it has said no.
Because of the order previous to that, my lord, it was not incorporated. But last order, my lord, that I have, my lord, this is a copy, my lord, which I've got from the internet, my lord, from the website.
No, that's true.
Commissioner
Where from they got it?
Commissioner Secretary is shown, my lord.
They have not done it here in the writ petition. In the writ petition, only respondent, 3 respondents.
But then in the order, that's the reason that I got confused. Because there is already an order, my lord.
No, you have already passed an order. We have
Yes,
seen that. You
that's
have already placed it before the court.
And because since it was there, I got confused, well, because they already shown as respondent of
Oh, but thing is this, that is not here. Check. No, that is true. That's why.
Check, but that's the reason I also got confused because it's already shown as respondent of 4.
No, you have given us that order. We remember we have seen that order.
Yes,
In the last occasion, you have placed that order before the court.
Yes. And thereafter, when I've got this order, so in this order also it shows your lordships are on last occasion, 27/7. The certified, rather the copy shows that the commissioner secretary is shown as respondent of 4, my lord. That's what that's it. I also got confused.
Lordship, in the cause list is showing finance and taxation, Lordship. Therefore, there is some confusion in the when the cause list is written as finance and taxation. So there's some confusion.
Finance, therefore finance.
Tell us what to do. But I don't know where from this finance have come.
In fact, my lord, in my petition, I have also specifically written, my lord, that there is some confusion with the implement, even though the implement was so and so. Or my lord, can I do one thing, my lord? Can I, my lord? Again, that will be a problem. That will also be a problem.
Yes, Mr. Doctor.
No, my lord, that will not be the solution, my lord. What I was thinking, my lord.
Where is that notification? I have not annexed. In fact, there was an earlier order, right?
Yes, my lord.
That order was of 27th of June 2023.
Yes, my lord.
But when that notification came,
Notification came over near about summer, similar.
notification from Dhari ko ulle sab.
It was somewhat nearby. Either it's preceded or after some. It was very.
Probably it's just the
Yes,
full
my
court
lord.
before the vacation.
Yes, well, something
That,
like
in that full court, we have taken that decision. Hello, High Court website.
since it was reflecting in the middle order, I also got confused. Perhaps it was that's why I thought it's done.
Because if it is prior to the notification, necessarily you will have a need not. Just please take your seat. Honor. It's from 19 June.
It came earlier, my lord.
Because that order, Brother Borua,
Yes, my lord.
will not have any effect.
That's the reason. Accordingly, my lord, I filed this fresh amended cause list, cause title. That I filed, my lord, as per this, my lord. Or if it is not there, then I'll file it, my lord. Then that will solve the issue, then, because the order is already there. Because it says, my lord.
Only what you have to do is only to 4 and 5 instead of 5. Your prayer is only 5.
5.
You made 4. Right?
Then we'll have to modify the prayer, my lord.
Either you withdraw it or file a fresh application, that's all.
Look, withdrawal is difficult, but they have to again come with 4 people, my lord.
You do not want.
My lord, some of them manage, my lord.
Do one thing. File an application that inadvertently the name of 4 has not been included in the prayer petition. So that should be 4 should be included. That can be done by your.
Well, I'll verify that.
That
Yes, that will take place. Yes.
The prayer of the council for the petition. That will be listed after 2 weeks.
Give privilege.
Left foot.